ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕ್ಯಾಮ್ರಾನೇ ಆನ್ ಆಗಿಲ್ಲ. ಕೋರ್ಟ್ ಆಫೀಸರ್
File an application for early hearing. Yes.
Serial number.
No.
Not
Please
serial
file an
number.
application, it will come. Yes.
Serial number 28. I may be permitted to withdraw the petition. I have not pressed.
The petitioner and learned counsel of petitioner have filed a memo dated 14/6/2023 in lieu of this court to withdraw the writ petition as not pressed. So, next paragraph. Memo is taken on record subject to all just exceptions. So accordingly, the writ petition stands dismissed as withdrawn. What do you want, sir? If it is a fresh matter, you please give. If it is a fresh matter, you please give.
Matter cell number 50, my lord.
Huh?
Matter cell number 50. I pay for the petition. I pray for an accommodation. Respondent is also. I'm looking to set back the mind. Represent the respondent.
2017 date given matter.
Set back the mind.
Huh?
Not
Final hearing.
next month.
You date ಕೊಟ್ಟಾಗ ಆರ್ಗ್ಯೂ ಮಾಡಲ್ಲ ಅಂತಂದ್ರೆ ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? Serial number 50 at the request of learned counsel for petitioner release this matter on 28th of June.
My lord, serial number 53, my lord, I appear for the petitioner. I have informed Mukkanappa. He said he will send his colleague there to the court, my lord.
Yes, anyone from Karnataka? ಇಲ್ಲ ಯಾರು ಇಲ್ಲ ಇಲ್ಲಿ.
A week's time, my lord, I have spoken to him, my lord. He said.
I don't understand. The other side is not there. Yes.
Much of it.
Serial number 85.
Huh.
Say preliminary hearing matter. Last week it had come up, one matter had come up. I had filed KBA. I gave the other number, it was directed to be posted today for preliminary hearing. It is now posted at 85. First time matter.
ಇಲ್ಲ ನೋಟಿಸ್ ತಗೊಂಡಿದಾರಲ್ಲ.
ಅಲ್ಲಲ್ಲ ಒಂದ್ರಲ್ಲಿ ತಗೊಂಡಿದ್ದಾರೆ. ನನ್ನ ಮ್ಯಾಟ್ರ್ ನಾವು ಪೆಟಿಷನರ್ ಇದ್ದಿದ್ದು ಅದು ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗಿಗೆ ಬಂದಿಲ್ಲ.
We will hear.
Immediately after preliminary hearing it may be taken.
ಅದು ನೋಟ್ ಮಾಡ್ತೀವಿ.
Please.
Yes.
Matter serial number 1. Dr. M. Deshpande.
Borrower before my lords challenging the proceedings under section 70 initiated by the respondent number 1, my lord. Before the respondent number 2, my lord. My lord, I had filed an application for rejection of the plaint which has been filed before the respondent number 2, my lord. My lord, I request my lords to kindly take the ledger extract, my lord, that has been produced, my lord. That has been provided to me as well as produced before the respondent number 2 authority, my lord. Annexure B, page number 31, my lord. My lord, the serial number 1, my lord, in that particular ledger extract, my lord, on 2/1/2019, the bank claims that 10 crore rupees has been disbursed to me. Lord, the bank further claims in its letter that at annexure D, page number 35, my lord, within 10 days of disbursement of the amount, my lord, my account has been classified as NPA, my lord, on 12/1/2019. I request my lords to kindly take annexure D, page number 35. It was not substandard, my lord. It continued, my lord. I have made the payments also, my lord. And the interest also has been charged on me, my lord. And it was never classified as a non-performing asset on 12/1/2019. Annexure D, my lord, page number 35, my lord.
So what was your prayer?
My prayer is that, my lord, give me the better particulars. Because my account within 9 days cannot be classified as an NPA. If my account is not classified as an NPA on that particular day, the plaint cannot be maintained.
Yes.
My submission is that application I filed before the authority. The authority is not ready to take into consideration that application. He says that you proceed with the merits of the matter. My submission is that, my lord, if the merits of the matter, if it is considered, and the amount is claimed is not as per the statement of account, and they are claiming around 22 crore rupees. If this particular ledger is taken into consideration, the amount is not to the extent at all. Only to fasten the liability, entire arbitrary action has been initiated. Therefore, my submission is that let there be a direction to consider my application, my lord. And only after considering that application, my lord, I will be in a position to proceed with the matter.
Learned
Tomorrow the matter is set down, my lord.
takes notice for
I am-
response number 1 and 2. Issue emergent notice to respond number 3. Returnable by 28th of June 2023. Learned counsel for petitioner is directed to serve a copy of the petition on the learned AGA.
Tomorrow it is set down for the cross-examination. Because I cannot.
Go on, sir. What is there? Ultimately, if they decide the matter without taking consideration your contention, you will have a good ground. Yes.
My lord, the difficulty is that
No.
the difficulty.
Let it come up, sir.
No,
Yes.
my submission is that, my lord, difficulty is that, my lord, this is not the amount due. Then I have to deposit a certain
Sir,
amount.
all that will be on the merits of the matter. How can we consider now? Not possible. Yes.
Same matter, my lord.
Huh?
Same matter
Same-
with respect of another account. my lord.
Yes.
My only endeavor is that, my lord, my only submission is that, my lord, tomorrow, my lord.
If you want to take hand summons, so please take.
Yes, I mean,
The petitioner is also permitted to take out hand summons. Yes.
but any early date, my lord, I will try to convince my lord.
You have to serve them. They have to come. What is this? Yes.
The petitioner before your lordship are, my lord, grantees. My lord, they have made an application for grant of land. And accordingly, my lord, annexure A applications, my lord, has been produced to all petitioners. And subsequent to that, my lord, kindly see volume number.
Grant of what?
Grant of 2 acres of land,
Agricultural land.
agriculture.
Ah.
And subsequent to that, grant order came to be passed.
Ah.
Then, my lord, Sagoli city has not been issued. Then we have approached this honorable court by filing a writ petition seeking direction. Accordingly, my lord, annexure AP, my lord, can we see?
Page number?
Annexure AP.
AB.
AQ. In page number 330, volume number 2.
Ah.
Then, my lord, kindly see EQ operative portion of the order. Your lordship will get to 342. Self a mistake agitu, then we have once again moved before the court. The learned counsel for the petitioner would submit that the batch of writ petition so and so prayer is not considered from form number 50. Instead, it is considered issuance of Saguli city in pursuant to the grant order dated 22/12/2012. Therefore, the order which is passed on 27/2/2012 confined only to the writ petitioner so and so. So far as writ petition number so and so are concerned, this court would direct the concerned authority to consider representation of the petitioner, implement the grant order dated 22/12/2012. The same is in accordance with the
Implement the grant order.
grant, my lord, this is, my lord, the petitioner's application has been placed before, my lord, the concerned authority. And subsequent to that, common order came to be passed by granting the year of 2012. Subsequent to that, Saguli city issue madlila. Then we have approached this honorable court. Then, my lord, this honorable court directed to consider. But subsequent to that, my lord, they have not considered. I have approached this honorable 346, my lord, by filing contempt. Contempt petition, my lord, after issuance of notice. That is, my lord, 346. There is several contempt petition has been filed. Then, my lord, kindly see annexure AR 342. The Manya Ucha न्यायालಯದ 342 dated 12/4/2021.
342.
342 AR. Endorsement ಕೊಡ್ತಾರೆ. After filing the contempt, Lord, Kanakpura ತಾಲೂಕು ಕಸ್ಬಾ ಹೋಬಳಿ
ಏನು ಪೂರ್ತಿ ಓದ್ಬೇಕಾಗಿಲ್ಲ, ಏನ್ ಹೇಳಿದ್ರು ಹೇಳಿ.
ಇದರಲ್ಲಿ they have rejected.
Within the prohibited distance ಅಂತ.
Yes.
ಆಯ್ತು.
2012, my lord, grant order came to be passed. 2014, my lord, this is falls within the, my lord, limit of, my lord, the corporation.
Sorry.
Then, my lord, 2012, my lord, grant order came to be passed. Within, my lord, 6 months, they should have issued Sagoli chit. They have waited up to issues. Therefore, that notification insofar as this land is concerned, we have challenged before this court. And my lord, Sagoli Chiti has not been issued. Therefore, my lord, both we have prayed before this honorable court to.
Why is this matter coming up in local bodies classification?
KLR RES.
Huh?
KLR RES.
ಏನ್ರಿ ಇದು? Two 0646.
Classification KLR.
The KLR matter. This
I think note.
this matter pertains to the Karnataka Land Revenue Act, and in fact, the classification mentioned by the petitioner is KLR-res. Full stop. Office is directed to place it before the bench having roster. Yes.
By fixing the date.
ನಾ ಫಿಕ್ಸ್ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. Yes.
Kata is issued in my favor, but is cancelled after lapse of 5 years. But on the basis of a complaint not filed by general public, not is the statement made. In fact, not identical matter, very same order, not on the court is already not granted an interim order. Like municipal, not under Municipalities Act, but there is no provision not for cancellation of Kata. That to hear not after lapse of 5 years. The order impugned is at page 203. Operative portion is at page 214. Kata was made in Lord Arnhem 2017, after which not a single window clearance has been given.
Learned AGA takes notice for respondent number 1. Who appears for this Chikmagalur municipality? Sri A. Nagarajappa, learned counsel, is requested to take notice for respondent number 2. Learned counsel for petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on learned counsel for respondent number 2 and a copy in the learned AGA. Next para. Learned counsel submits that under similar circumstances, where the second respondent cancelled the Kata registered in favor of many of the allottees in the Mysuru coffee curing works layout, has passed an interim order of stay in WP number 14639 of 2022. Learned counsel prays for similar orders. Stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned order dated 16/5/2022.
Oh.
Why are you so late
Delay ಮಾಡಿದ್ದಾರೆ ಅವರು. They had to take a decision to come and they thought not this order would anyhow to the benefit because same order.
ಸರಿ.
ಆಮೇಲೆ then not inform them that you can't allow that or they have to independently challenge. Very same order was challenged.
22 at annexure AA, comma till the next date of hearing.
Great.
Here for the creation. Has purchased the land bearing survey number 48 of Kathali village, Sajapura, over Anekatala. For 303 sale deed with 3 acre property. Subsequently approached the deputy commissioner for conversion. Conversion has been made. Thereafter, you are approached the fourth respondent for change of Kata. He has passed an order change of Kata in my name, and I produced all those. Then if I have paid taxes. Now he has been issued annexure A that they are going to cancel the Kata. Page number 70. Against that order, you are asking that I am approved.
Oh, you have a remedy under 269 for the executive officer.
ಅವ್ರು ಏನ್ ಹೇಳಿದಾರೆ ಇಷ್ಟೇ.
ಈ ನೋಟಿಸ್ ತಲುಪಿದ 30 ದಿನಗಳ ಒಳಗಾಗಿ ದಾಖಲಾತಿಗಳೊಂದಿಗೆ ನಿಮ್ಮ ಲಿಖಿತ ಸಮಜಾಯಿಷಿಯನ್ನು ಈ ಕಚೇರಿಗೆ ನೀಡಬೇಕೆಂಬುದು ತಿಳಿಸಿದೆ.
All the complaints are also made.
ಮಾಡಿ.
All the ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ ನಾನು. ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ. ಅವರು local politicians ನಲ್ಲಿ they are interfering with me. And I filed a suit for injunction and so on.
If they pass an order which is not in your favor, you go before the executive office.
But
There is a direct provision, sir. There is an appeal remedy.
I agree with 269 is very clear. What I am submitting before you are issuance of this notice without an explanation and also the things.
Sir, it is a notice.
Illegal.
Yeah, they are calling upon you to offer explanation.
Yes.
Why it should not be cancelled.
Yes.
Give your offer explanation.
And I give
If
the
they further pass orders, then you go before the executive officer.
ಅಲ್ಲಿ ಏನಾಗಿತ್ತು
ಬರ್ಕೊಳ್ಳಿ.
ಒಂದು ನಿಮಿಷ.
Learned HCGP takes notice for respondent number 1. Notice to the other respondents is not necessary for the following reasons.
For respondent you notice.
The petitioner seems to be aggrieved of the impugned notice dated 8/3/2023 issued by the Panchayat Development Officer of
Shantipura.
The fourth respondent, Shantipura Gram Panchayat, calling upon the petitioner to furnish documents and offer explanation within a period of 30 days from the date of receipt of the notice as to why the Kata registered in the name of the petitioner in the office of the Gram Panchayat should not be cancelled. Stop. Next para. Normally,
I gave explanation in
this court does not interfere in in writ petitions where a notice is challenged. Stop. In the notice, in the impugned notice, the petitioner has been called upon to offer explanation. Stop.
Paid explanation 123.
It is the contention of the petitioner that the petitioner has given written submissions and offered explanation, stating why the Kata should not be cancelled. Full stop. Nevertheless, if the Panchayat Development Officer or the Gram Panchayat passes any order cancelling the Kata, the petitioner has an alternative efficacious remedy under section 269 of the Karnataka Gram Swaraj and Panchayat Raj Act 1993 to challenge such an order before the executive officer of the Taluk Panchayat. Full stop. Such alternative efficacious remedy being available to the petitioner, and more so because no such order has been passed by the Panchayat Development Officer or the Gram Panchayat till now, no cause of action arises for the petitioner to have filed this writ petition. Full stop. Next para. Consequently, the writ petition stands dismissed.
At least my application will be disposed of at least.
ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ವಲ್ಲ ಅದು?
ಅಲ್ಲ ಅವ್ರದ್ದು ನಮ್ಮ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಟ್ಟ ಮೇಲೆ
ಪಾಸು ಮಾಡ್ತೀರಾ? ಎಸ್.
The petitioners are aggrieved with the action of the third respondent, with the joint vision of the cooperative societies. Now and then, Lord, is found Lord passing an implement order, stalling the registration process. Suyomoto, he passes an order, thereafter he recalls the order. There is a series of orders. Lord, what happened for the 2020 and 25, a new board came to the assume the charges. Within 4 months, he initiated a few motor proceedings under section 65 for inspection. Thereafter, he filed series of proceedings under section 29C, resulting in fall of quorum because most of the directors they gave voluntarily resigned the post. Special officer was appointed. Not during the special officer has taken charge. The section 65 proceedings was challenged before this court. This court granted interim order. And thereafter, he was not reluctant to conduct elections to the society. We came again before the Zonal court. This court gave a direction to conduct election. When this order was passed, Lord, he passed another order under section 64 to conduct an inquiry. When there was no board of management and special officer was officiating. Lord, then now what has happened? Now, Lord, on 27/1/2017-3/23, the new board takes charges. No
election was conducted.
Election was conducted only on 17/3/23. New board takes charge.
Yes.
No decision was taken. No resolution was passed for conducting the process of registration. On 10/4/23, he again passes a order that no site should be registered. Note, this is a site note which was formed in 1992. Out of 3,003 sites, 2,800 sites are already sold by registered sale deed. Note, this officer notes on 16/8/21. Suyomoto passed the order not to allot the sites. On 31/1/22, he vacated the order. Then again 24/2/22, he passes the order and then again dissolves the order on 21/5/2022. And there are also not he has given certain letters to register the sites in favor of certain members.
Let us see.
But I sought action against this officer also by making him as a parting person as responsible for. It's not considered by other authorities.
Yes.
I also referred Supreme Court judgment which says.
You have made allegations against.
Yes, my lord. Respond number 3, my lord.
Correct. ಅದನ್ನ ಹೇಳ್ತಾ ಇರೋದು. They have made allegations against him.
Yes.
ಅದೇ. Learned AGA takes notice for response number 1 to 3. Issue emergent notice to respond number 4. Returnable by 28th of June 2023. Learned counsel for the petitioner is directed to serve 2 sets of copies of the petition along with annexures from the learned AGA. Stop. The petitioner is also permitted to take out hand summons to respond number 4. Yes.
In the meantime, not the order may be stayed.
Yeah, ಎರಡು ವಾರದಲ್ಲಿ ಏನು ಆಗಲ್ಲ. Come, we'll see, we'll dispose of the matter.
MG 7.
The third respondent is adjacent property owner. So my property is a neighbor. He is constructing the illegal construction without obtaining the license and without giving the setback.
15/4/2023, you have given a complaint.
Yes, as per annexure A and B, I have given a complaint to the
ಯಾರಿಗೆ? ಮೆಡಿಕಲ್ officer. Medical officer
and BBMP officer. He is the recognized.
He is not the authority.
Executive engineer.
ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
Yes, my lord. Second, commissioner head of the office BBMP and the medical officer, health office, BBMP, FR division, FR. So, but they have not been taken any consideration of my representation. Ma'am.
No,
Plan is they should give the presentation to the concerned AW. And if there is a plan, then they should give the presentation.
no, whatever it is, a complaint has been given by this person. The commissioner has to look into it and send it to the concerned officer to conduct an inquiry, find out whether the allegation is correct. If it is correct, then proceed in accordance with law. Why are you not proceeding?
There are
Workplace.
photo snaps also given, my lord. Page
Learned,
number 18.
Counsel Sri Pawan Kumar, who is present in the court, takes notice for response number 1 and 2. Learned counsel for petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on the learned counsel for the respondent BBM. Full stop. Next para. The petitioner seems to have made a complaint to the health officer, BBMP, Hebbala. Hebbala idu.
All division.
Hebbal subdivision, Bengaluru on 15/4/2023.
Was received on 18/4/2020. Document was given.
Complaining that his neighbor has been putting up illegal construction, and therefore he requested that action be initiated in accordance with law. Stop. Thereafter, the petitioner caused a legal notice dated 30/4/2023 at annexure B to the commissioner, BBMP, and the health officer, Hebbal, once again bringing to their notice the illegal construction being taken up by the neighbor. Stop. Then the council submits that action has not been initiated by the respondents, although 2 complaints have already been made by the petitioner. Full stop. Next para. Having regard to the prayer made in the writ petition and the contentions of the learned counsel for the petitioner, this court is of the considered opinion that there is no need for this court to issue notice to respondent number 3, against whom complaints have been made by the petitioner. Full stop. On the other hand, directions are required to be issued to the commissioner and the concerned assistant executive engineer to take action on the complaint made by the petitioner. Full stop. Next para. Consequently, the writ petition stands disposed of with a specific direction to the chief commissioner, BBMP, to take note of the complaints made by the petitioner, more particularly in annexure B, dated 30/4/2023, which is addressed to the commissioner. Stop. Action shall be initiated in accordance with law against the violator, and the action shall be taken to its logical ends as expeditiously as possible, and at any rate within a period of 3 months from the date of receipt of a copy of this order. Full stop. Ordered accordingly.
The commissioner is the because now the chief commissioner appellate authority of the
Zonal commissioner. Instead of chief commissioner, make it zonal commissioner of the concerned jurisdiction. Yes.
Following the annexure K and H, your lordship, the second and the third respondent passed the order. I am the permanent resident of the scheduled property, and they have issued the PO and CO, provisional order and confirmation order. The building is the unauthorized construction building. Kindly see the page number, your lordship. Confirmation order, page number 37, action H, your lordship. In the first para, last line, your lordship. ಶ್ರೀ ಶಂಕರಪ್ಪ ಬೀರವರು ಅನಧಿಕೃತವಾಗಿ ಕಟ್ಟಡವನ್ನು ನಿರ್ಮಿಸಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. They are saying unauthorized building, your lordship. And continuously, second para, your lordship. ಸದರಿ ಮೇಲ್ಕಂಡ ಸ್ವತ್ತಿನ ವಿಳಾಸದಲ್ಲಿ ಕಟ್ಟಡದ ಸ್ಥಳ ಪರಿಶೀಲಿಸಲಾಗಿ ಕಟ್ಟಡದ ಮಾಲೀಕರು ಮಂಜೂರಾದ ನಕ್ಷೆಗೆ, ಅಲ್ಲಿ ತಾವೇ ಹೇಳ್ತಾರೆ ಮಂಜೂರಾದ ನಕ್ಷೆಗೆ ವಿರುದ್ಧವಾಗಿ ಮತ್ತು ಬೃಹತ್ ಬೆಂಗಳೂರು ಮಹಾನಗರ ಪಾಲಿಕೆಯ ಅಧಿನಿಯಮ 2020 ನಿಯಮ ಹಾಗೂ ಬೈಲಾಗಳನ್ನು ಉಲ್ಲಂಘಿಸಿ ಅನುಮೋದಿತ ನಕ್ಷೆಗೆ ವ್ಯತಿರಿಕ್ತವಾಗಿ ಉಲ್ಲಂಘನೆ ಮಾಡಿ ಕಟ್ಟಡ ನಿರ್ಮಾಣ ಮಾಡಿರುವುದು ದೃಢಪಟ್ಟಿರುತ್ತದೆ. They have not filed any Mahazar report. They have not filed any inquiry report. Nothing, your lordship.
Whom?
So before
When
the
notice is given, you don't appear. What they will do?
Your lordship, I filed the appeal, my appeal.
Elli the appeal.
Kindly see the page number 39, your lordship. I filed before the respond number 1.
Thereafter, you filed an appeal.
Yes. Thereafter, they passed the order.
Huh?
Kindly see the page number 47, you have confirmed the same order. Annexure K.
That order has been confirmed.
Yes.
Angeli.
Paragraph 3, your lordship, the respond number 1 filed LCR and submitted in writing that the reply of the appellant was not satisfactory. That reason only they have to dismiss my appeal, your lordship.
Huh?
And the kindly see the page number 48, your lordship. Paragraph
48.
Yes.
Huh.
Paragraph 3, your lordship.
The
respond number 1 filed LCR and submitted in writing that the reply of the appellant was not satisfactory. So that reason only they have to dismiss my appeal, your lordship. And my entire building is the old building. I purchased this property in 1986 and I constructed the same year. Now they are saying the building is unauthorized building.
Where have you stated so?
Kindly see my reply, your lordship.
In your appeal.
Appeal, your lordship. Once.
In memorandum of appeal.
Yes, your lordship.
What have you stated?
Paragraph 3, your lordship.
Yes.
It is submitted that at the time of purchase of the property, the house has been constructed in the property and the applicants have obtained transferred the water connection to the said property in their name. The applicants have obtained the electricity connection to the property. The old copies of electricity bills are produced herewith and so, your lordship, and continuously. And even though I have produced the taxpayer receipt, electricity bill, everything, your lordship. And when the neighbor has given the complaint, that reason they have only issued the PO and CO, your lordship. He is the adjacent to me.
Yes. Perfect. Learned Counsel Pawan Kumar, who is present in the court, takes notice for all the respondents. Learned Counsel for petitioner is directed to serve 2 sets of copies of the petition along with annexures and learned counsel for the respondent. We'll stop. Next paragraph. Learned counsel for the petitioner submits that in the memorandum of appeal filed by the petitioner before the Chief Commissioner, BBMP, in appeal number 19/2022. 21. The petitioner herein has clearly stated that he purchased the property in question along with the existing building under a registered sale deed dated 22/10/1986. Stop. The Kata was registered in the name of the petitioner in the office of the BBMP, and the petitioner has been paying the property taxes regularly. Stop. it was specifically contended by the petitioner that the petitioner has not put up any new construction. And therefore, action could not have been initiated at the instance of one Dattatreya. Full stop. Learned Council submits that the Chief Commissioner has not taken notice of these aspects and has simply accepted the submission of the Assistant Executive Engineer and held that the explanation offered by the petitioner is not satisfactory. Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned order dated 26/4/2022. ಬಹಳ ಹಳೇದಾಯ್ತಲ್ಲಮ್ಮ ನೋಟಿಸ್.
They have not intimated the order, your lordship.
Huh?
They have not intimated the final order, your lordship.
26/4/2022 at annexure K till the next date of hearing.
Acha.
Yes.
P5/11/1992. PDA has allotted the site in favor of Indiramma. 7/10/1995. She obtained the sanction form from the BDA and put up the construction. On 24/11/98, Indiramma sold the property in favor of Kishan Rao. Petitioner purchased the property on 9/9/2002.
Panashankari third stage.
2002 ನಲ್ಲಿ property was purchased by me.
Along with 11.5 squares construction.
Existing structure as per the sanction plan issued
Yes.
by the BDA.
Yes.
I did not ask for sanctioning the plan from the BBMP. There is no proceeding for revision of the tax. In spite of it, a notice came to be issued. So let me kindly see the notice. Manager page 30. Invoking the provision section 313. Assistant Executive Engineer issue a notice calling upon me to produce the title deeds, Kata certificate, sanction plan, commencement certificate, tax paid receipt. For what purpose? I did not ask for sanctioning the plan. I did not ask for revision of the tax.
What are BBMP Act?
The notice itself is without jurisdiction. It is only zonal commission has to issue notice. If there were to be a proceeding pending, let us see section 313.
Summons to attend.
Summons to attend and give evidence. Produce document.
The zonal commissioner may summon any person to attend before him and to give evidence or produce documents as the case may be in respect of any question relating to taxation or inspection or registration or to the grant of any license or permission under the provisions of this act.
I did not ask for anything else.
Perfect. Paragraph same, Pawan Kumar. Takes notice for both the respondents. Learned Counsel for the petitioner submits that the Assistant Executive Engineer, Respondent Assistant Executive Engineer, Girinagara Subdivision, BBMP, has issued the impugned notice purportedly under section 313 of the Brihat Bengaluru Mahanagara Palike Act, 2020, calling upon the petitioner to furnish documents of title and the sanctioned plan, etc. within a period of 3 days, or failing which, the existing building on the property in question shall be considered as unauthorized construction. Next para. Learned counsel submits that
The 24th one, the zonal commissioner can delegate his powers to the DDP
70.
74. The case is previously notification for call for the document. Taking any other.
The zonal commissioner shall perform the following functions. Really there? Where is the power to delegate? Subject to the rules made by the state government, the zonal commissioner may delegate. So he has delegated. There is a notification.
This is the notification.
No, we do not know. It may be there. Or submits that a notice or summons under section 313 can be issued only by the zonal commissioner. And the assistant executive engineer could not have issued such notice or summons. So, even otherwise, comma, it is submitted. You document submit madidira. Even otherwise, it is submitted that the petitioner has furnished all the title deeds, copies of the title deeds on 5/6/23, immediately after receipt of the impugned notice, to substantiate that the construction on the property was put up way back in the year 1995. And the petitioner is the third purchaser in row, along with the constructed building. Stop. There was no occasion for the officers of the BBMP to have issued the notice. Stop. Next para. The respondent the second respondent, assistant executive engineer, is hereby directed not to precipitate the matter any further till the until further orders. Stop. Learned counsel for the petitioner, for the respondent BBMP, is directed to secure instructions from the second respondent, taking into consideration the contentions of the petitioner. Stop. Release this matter on 1st of June. 22nd of
Day before yesterday, permission is granted to file appeal before the joint chief commissioner.
ಯಾವ್ದು?
Repetition number 12004 of 2023.
12004
of 2023.
dated
Dated Monday.
well same order. So Nagendra Kumar, ಇಲ್ಲ ಕುಮಾರ್ ಅಂಡ್ ಭಟ್ ಅಂತ ಇದೆಯಲ್ರಿ? ನಾಗೇಂದ್ರ ಕುಮಾರ್ ತೋರಿಸ್ತಿದ್ದಾರೆ. Arvind Kumar. What is this matter?
There is no research.
ಅಲ್ಲ ಫಸ್ಟ್ ಸೇಲ್ ಡೀಡ್ ರಿಜಿಸ್ಟರ್ ಆಗ್ಬೇಕಲ್ಲ. Learned AGA. Take notice for response number 1 and 2. So emergent notice to respond number 2. 3. Returnable by 28th of June. Learned counsel for petitioner is directed to serve a copy of the petition on the learned AGA.
The petitioner had services to the respondent number 1 minus. The arbitration agreement is at annexure B, page number 25. Arbitration clause is at page number 25. Agreement starts from 14 minutes. Clause 10. Notice is at page number 36. Clause 10 is a clause for arbitration. Notice for arbitration is at page number 36.
Where is the notice of claim? What is your claim?
Claim is, my lords, in the sense I had rendered some services to the respondent number
Where is the
1.
notice regarding claim?
36 minutes.
36.
Have invoked the arbitration clause at page number.
No, where is the claim, sir? First of all, you have to claim because see, there are so many aspects covered under that arbitration clause.
Please, minutes.
First, you will have to try to resolve it.
Please.
There are so many other avenues given there.
Annexure C. Minutes.
Annexure C. Yes.
Annexure C, Annexure D, and Annexure E. Minutes. The correspondence between the petitioners and the respondents.
ಏನಂತ ಕೇಳಿದಿರಾ?
As the invoices are attached in Annexure D minus page number 31 and I have claimed the amount minus.
Huh?
The claim is done under Annexure D minus page number 31. These are the invoices which I had raised on the respondents. And the total claim is made.
Yes.
Thereafter, one more notice is issued under page number 34 minutes, Annexure E.
Yes.
Where I have stated that you are in breach of the clauses of the agreement. Then the arbitration notice is issued under 36 minutes, Annexure F. They have replied to the arbitration notice minutes under page number 41, Annexure G. I invoked the arbitration clause under page number 40 minutes, paragraph number 23.
You not suggested,
I have suggested.
where is it?
Page number 60, and Excel K. In furtherance to that notice, I have issued one more notice. Page number 60 is the notice.
They gave a reply.
They gave the reply. They have not disputed the arbitration clause, only the amount has been disputed. Thereafter, this is in continuation of the notice for arbitration dated 12/2/2021, page number 60, and Excel K. Paragraph number 5 is the nomination.
They have sent a check.
That is a dispute, Manas.
Ah,
They are saying that they have to totally give us 10 lakhs. But there are two packages out of which I am claiming 40 lakhs. Page number 60 is the nomination. Annexure K. Paragraph number 5.
issue notice to the respondent.
There is also similar matter.
All the different issue notice.
Lord, this is a dispute between the partners of a partnership firm, wherein, my lord, the respondent partners have mismanaged the partnership firm and diverted the funds of the partnership firm by creating a trust and also leasing the properties to the trust, which is the property of this particular partnership firm. Lordship will get the partnership deed at Annexure B, page 32. Arbitration clause is at page 34, page 35, my lord. Clause 16. All the disputes which arise between the partners with regard to the partnership business or any interpretation of these presents, the matter shall be returned and settled through arbitration. The arbitration proceeding shall be in accordance with the provisions of Arbitration Act 1940.
Yes.
Then, my lord, I issued the notice. Annexure L, page 20. Now, 21 is the notice.
121.
121, my lord. And the demand what I made, lordship will get at the page 130, my lord. Paragraph 36. The first prior, my lord, I had seeking for his eviction from the property because he is one of the partner who is the respondent herein. He is occupying the premises of the firm. And the clause C, my lord, the other one, where, my lord, I had quantified the claim against him for 38 crores 90 lakhs and demanded to make this payment within 7 days, which he has failed to do so, and he has also replied to this notice. Lordship will get the reply notice at Annexure M, page 138. Lordship may kindly see his refusal to cooperate for arbitration is at page number 147, para 22. The partnership firm has maintained the day-to-day accounts and they are certified by the qualified and approved chartered accountants. Further, the partnership firm regularly filed income tax returns. Further, our client has regularly received their share of profit from the partnership from up to date. Therefore, the question of committing breach of the partnership deed by our clients will not arise. There is no dispute that arising or invoking arbitration clause 16 of the partnership deed. Our clients disapproves the nomination of arbitrator Sri Girish Kodgi made by your client. So, since he has refused to accept the nomination made by me,
Who filed this suit?
sorry, my lord,
Who filed this suit?
there is no suit, my lord.
There is a reference to a suit in the notice reply.
There is a suit. Yes, sorry, my lord. The suit has been filed by him. He has filed an injunction suit before the lordship at dated para 11.
OS number 180.
185 of 2000. It is an injunction suit filed against the partners.
You have filed.
No. The respondent, the other partner has filed. Yeah, basically, my lord, this petition, the arbitration claim is for the settlement of accounts as per the Partnership Act.
Notice to the respondent.
Number 85, sorry, sir.
Yes. Right, pass on.
Hold on. Fine.
We could pass over, madam.
For what?
We are not going to the court, madam.
Why do you need serial counsel for rectification of office objection? Matters come up for rectification of office objection raised on IA number 1 of 2023. Why do you need arguing counsel, madam? You should have taken instruction. Blank in prayer para. Yes.
My lords, I'm seeking for an extension, my lords. I'm producing the procedure order. The judgment is reserved, my lords. So, my lords, the period expired in February 2023, my lords.
What period?
Period for passing the arbitral award, my lords.
Hmm.
The arbitral proceeding is sought for an extension.
Hmm.
That extension expired on February 2023, my lords.
By which order?
By virtue of order dated, my lords, virtue of order dated, my lords, 4/2/2023, my lords. I stand corrected. It was allowed on 3rd of September 2022 by giving a time till 2nd February 2023, my lord.
Reserved for orders, isn't it?
Please, my lord. The last procedure order reserved for the judgment. It's completed, but my lord, the period for completion has been extended in terms of section 21 of the Arbitration and Conciliation Act. The joint application on behalf of both the parties.
Arbitration Act.
The section 29A.
Order on IA number 1 of 2020. By order dated 3/9/2022, this court accepted the cause shown in the affidavits filed in support of the joint application, taking into consideration the averments made in the joint application and extended the period for completion of the arbitration and for passing of the award by 6 months from 2/8/2022. That was expired in February itself.
Please, my lord, we have filed this joint application
Hmm.
for extension.
However, this joint application has been filed under section 29 capital A bracket 5 of the Arbitration and Conciliation Act, 1996. Seeking extension of time while placing on record that where are that order that we just read out now?
The procedure order to
We're giving it along with the memo now.
please, my
ಏನಿಲ್ಲ? A procedural order dated 11/2023 passed by the arbitral tribunal stop. While pointing out to the said order, learned counsel submits that by order dated 11/6/2023, the arbitral tribunal has reserved the matter for pronouncement of orders, for pronouncement of the award. Stop. Next para. Nevertheless, this application has been filed formally since it is mandated under the provision that unless there is an extension of time granted by the court, the award cannot be passed by the arbitral tribunal after the expiry of the period. Stop. Expire. Consequently, the application is allowed. The time for pronouncement of the award stands extended.
8 months, my lord, effect from 12 to 2023.
We will grant another 4 weeks or 8 weeks.
My lord, it's 8 weeks.
In
that even 8 weeks. From today.
For a period of 8 weeks from today. Stop. Ordered according. Yes. IN number 1 of 2023 or terminate the mandate of why?
Subsequently, he appeared, he gave an all the way from the commencement of the cross examination is about to begin. At that time, there were certain discussions pertaining because the GPA holder, the SPA holder of the respondent and the counsel for the petitioner had agreed to cross-examine the previous discussion of the EC. Subsequently, I don't know what happened. He tendered an ant memo right to the place to the arbitrator, asking them to turn their appeal arbitral proceeding. The objection was filed to it, and then he's now proposed this on to put under the said time.
You filed objections to this one?
No, well, there's a question matter is coming. Objections. Of the petitioner is that the arbitrator is because he was helping the counsel of the respondent in framing the questions to cross examination. And there is temporary and handwritten memo.
Office objections are overruled. It's off. At the request of learned counsel for the respondent, a week's time is granted to file objections to IN number 1 of 2023. Yes. That has been settled. Third. The parties along with the learned counsels have filed a joint memo dated 14/6/2023. and the learned counsel submit that the parties have settled the matter and the petition may be disposed of in terms of the joint memo. Full stop. In terms of the joint memo, respondent number one society has issued an allotment letter dated 7/6/2023 to the petitioner in respect of site number 6, measuring 12 meters into 18 meters, which is a corner site, carved out of survey number 121/1 and 121/2 of Ajanahalli village, Tavarekere Hobli, Bangalore South Taluk, in SLN city. So, it stated, it is agreed that within 120 days from the date of payment of additional amount, the respondent society will register the site in favor of the petitioner. Stop. The petitioner has agreed to pay an additional sum of rupees 285 per square feet, apart from the amount already paid by her to the society.
What would be paid within 4 weeks? The petitioner will pay the amount within 4 weeks.
Sorry, ಬಂದಿದೆಯಲ್ಲ ಅಲ್ಲಿ?
ಗೊತ್ತಿಲ್ಲ.
The petitioner undertakes to tender the additional amount as agreed in the joint memo within a period of 4 weeks from today. In view of the joint memo filed by the parties, nothing further survives the consideration in this petition. In these petitions, full stop. Accordingly, the petitions stand disposed of in terms of the joint memo.
Connected matter, site number 5. The petition part is L. Satyanarayan. Lordships have said her.
ಅದ್ರಲ್ಲಿ ನೋಡ್ಕೊಂಡು ಕರೆಕ್ಷನ್ ಮಾಡೋಣ. 39093 ಅಲ್ಲಿ ದಿ ಪೆಟಿಷನರ್ ಇಸ್ ಸವಿತಾ, ಸೊ ಅಲ್ಲಿ ಹಿಸ್ ಅಂತ ಹೇಳಿರೋ ಕಡೆ ಹರ್ ಅಂತ ಮಾಡ್ಕೊಳ್ಳಿ. ಆಮೇಲೆ ಜಾಯಿಂಟ್ ಮೆಮೊ ಅಮೌಂಟ್ ಸೇಮ್ ಅಲ್ಲ, ಏನ್ ಚೇಂಜ್ ಇಲ್ಲ. ಸೈಟ್ ನಂಬರ್ ಮಾತ್ರ ಚೇಂಜ್ ಆಗುತ್ತೆ, ಅದನ್ನ ನೋಡ್ಕೊಂಡು ಮಾಡಿ. ಅದರಲ್ಲಿ ಸೈಟ್ ನಂಬರ್ 6 ಸವಿತಾ ಅಲ್ಲಿ, ಈ ಸತ್ಯನಾರಾಯಣ ಅವ್ರದ್ದು ಸೈಟ್ ನಂಬರ್ 5. ಮೆಜರ್ಮೆಂಟ್ ಸೇಮ್ ಅಲ್ಲ, ಸೊ ಅದೇ ಅಷ್ಟು ಮಾತ್ರ ಚೇಂಜ್ ಆಗುತ್ತೆ.
We have received the original letter of allotment, copy of the release order and copy of the layout plan.
ಇನ್ನೊಂದು ಸೆಂಟೆನ್ಸ್ ಸೇರಿಸ್ಕೊಳ್ಳಿ. The petitioners admit of having received the allotment letters.
Copy of the release order and copy of the layout plan.
Copy of the release order and copy of the layout plan.
Cost has to be paid, my lords. Cost has to be paid, but which of the respondents would not
Yes.
pay on the last occasion? And I need to pay the cost.
Go to learned counsel for response number 2 to 5. ಒಬ್ರೇ ತಾನೇ ಇರೋದು, ನೀವು ಒಬ್ರೇ. You are the only counsel for all of them. Huh? Please give it to. The petitioner is permitted to pay costs of rupees 1,000 to learned counsel for response number 2 to 5.
Paid.
Stop. The same is paid to the learned counsel today before this court. Yes.
Suit is almost settled and terms he has given terms and suit for declaration is pending before civil court. I will report there and then I will withdraw the case. And party has not come today, so I will discuss with them. So first week any day.
At the joint request of the learned counsels, release this matter on 5th of July, 3rd of July.
Petitioner, number 20.
Here office objection. Objection is overruled. Office objection raised on the wakalat filed by learned counsel Shri Pradyumna L. Narsimha is overruled. a communication dated 27/3/2023 made by the judicial member of the Karnataka Appellate Tribunal, Bengaluru, to the learned Registrar General of this court, seeking extension of time. Stop. It stated that the bench has only a single member, and for want of quorum, the matter could not be taken up. So, next para. Consequently, the time for compliance of the orders passed by this court on 25th of July 2022 stands extended till 31st of August 2023. This order shall be communicated to the Karnataka Appellate Tribunal. Yes.
On the last occasion, my lord, this honorable court was pleased to, grant an opportunity to the petitioner to approach the respondent bank and, my lord, to work out the payment schedule as far as the due amount is concerned. Particularly, my lord, petitioner had approached the bank. Some talks have taken place. My lord, pursuant to that also, my lord, yesterday petitioner has made a payment of 7 lakhs in addition to the earlier payment of 3 lakhs in the last occasion they was made. So according to them, my lord, they say again 38 lakhs is still due and payable. So I received a statement from the bank.
Not Learned Counsel for Respondent number 3, Cooperative Bank, has filed a memo along with a statement from the bank showing the amount due from the petitioner. So, Learned Counsel submits that as on 9/6/2023, the petitioner has paid a sum of rupees 53 lakhs
53 plus yesterday's 7.
as on 9/6,
Please,
53 lakhs, and the balance payable is 45 lakhs. We'll stop. Next para. learned counsel for petitioner submits that the petitioner has paid a sum of rupees 7 lakhs yesterday to the third respondent bank. Stop. Learned counsels are requested to make their submissions after taking instructions from their parties. Stop. Release this matter on.
My lord, in the meanwhile, my lord, also negotiate on the final amount that my lord should not look as if I have admitted the balance. Because what is there? Some sort of.
28th of June. Stop. Next para. The petitioner is free to approach the respondent bank and seek for any reduction in the amount to be repaid to the bank. Yes. Interim order granted earlier, chance extended to the next date.
But if you file appeal before the patent authority may not.
For renewal of trade license. ಏನ್ ಮಾಡ್ತಾರ್ರಿ?
Put it to file appeal before the authority may not attend as meanwhile. And directing the second respondent not to precipitate in the matter may not. Because the so moto the second passed the order. Because for last
Now they have heard you and passed orders.
With not proper hearing, my lord, it's not proper hearing.
ಅದ್ರಲ್ಲಿ in ಏನ್ extra ಏನಿದೆ? They are saying the general public are objecting because all vehicles are parked haphazardly on the road and there is noise pollution.
Recent development.
ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ?
Recent development. For last 15 years are running the license in my lord.
ಸರಿ, ಏನ್ ಮಾಡೋದು? ಇವಾಗ ಹಳ್ಳಿಗಳಲ್ಲಿ ಈ ಪ್ರಾಬ್ಲಮ್ ಇದೆ, ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ?
Because of some local politics, this will happen because I'm in the street, because without any public.
Anyway, you want to challenge it, you challenge it in manner.
Liberty to.
Learned counsel for the respondent. So, for the second respondent, Gram Panchayat has filed a memo dated 14/6/2023 along with a copy of order dated 7/10/2022 said to have been passed by the executive officer of the Taluk Panchayat, Somarpet. So, learned counsel submits that the appeal filed by the petitioner has been rejected by the executive officer of the Taluk Panchayat. Stop. Next part. Learned counsel for the petitioner submits that the rejection of the application for renewal of the trade license is in violation of principles of natural justice. Stop. Even otherwise, it is submitted that there is a remedy available for the petitioner to raise a challenge to the order passed by the executive officer of the Taluk Panchayat under the provisions of the Karnataka Gram Swaraj and Panchayat Raj Act 1993. Stop. Accordingly, the petition stands disposed of. Granting liberty to the petitioner to raise a challenge to the order passed by the executive officer in a manner known to law. Stop. Ordered accordingly.
Till then, request for not to proceed in the matter now. Beginning of the appeal, my lord.
Illa, was there such an order till now?
The true fact, but
till now there was no such order. How can we pass an order now?
At any moment, there example.
No. Till now, you are not protected by an interim order passed by this court.
No.
Then, while disposing of, how can we grant such a agadilla?
This court having the
No, sir. During the course of these proceedings, you didn't have that benefit.
No,
ಮತ್ತೆ ಇವಾಗ ಏನ್ ಕೊಡಕ್ ಬರುತ್ತೆ?
frankly submitting that there is no interim order, but in the meanwhile, the second respondent may take any action.
Sir, without there being a trade license, you cannot run the workshop like that. Yes.
Liberty will not.
Liberty ಕೊಟ್ಟಿದೀವಲ್ಲ. Yes.
Appeal for the petitioner. ಯಾವುದು? ಸರ್ವ್ ಮಾಡಿದ್ದೇವೆ ನಾವು. Comment ಇದೆ. Now my grievance is against 5 to 8.
Not filed, copy served, acknowledgement.
ಸರ್ವ್ ಮಾಡಿದ ಅಕ್ನಾಮೆಂಟ್ ಇಲ್ಲ ನನ್ನ ಕೈಯಲ್ಲೇ ಇದೆ.
ಅಲ್ಲ ಯಾರಿಗೆ ಸಿಕ್ಕಿಲ್ಲ ಕಾಪಿ? ಅದೇ ಐಎ ಕಾಪಿ ಯಾರಿಗೂ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ.
ಅಲ್ಲ 5 to 8 are contesting party. 5 to 8. Matter is simple as one. This honorable court has issued a direction as per Annexure A. That order was not obeyed by the BBMP. ಆಮೇಲೆ ನಾನು ಕಂಟೆಂಪ್ಟ್ ಹಾಕಿದೆ.
ಏನಂತ
ಕಂಟೆಂಪ್ಟ್ ಹಾಕಿದ್ರೆ ಕಂಟೆಂಪ್ಟ್ ನಲ್ಲಿ
ಏನಂತ
ಆರ್ಡರ್ ಇವ್ರ ರಾಷ್ಟ್ರ ಕೈಲಿಸಿ Annexure A.
ಏನಂತ
Direction was issued at page number 23. Therefore, BBMP is directed to take the recommendation dated 14/6/21 issued by the assistant engineer to its logical end at the hands of Zonal Commissioner of the BBMP and further action in terms of section 356 of the said Act of preserving all copies on the respondent want to court and granting an hearing the affected party.
ಏನ್ deviation
ಏನಾಗಿದೆ 6 ಫ್ಲೋರ್ ಬಿಲ್ಡಿಂಗ್ ಕಟ್ಬಿಟ್ಟಿದೆ ನನ್ನ ಪಕ್ಕದಲ್ಲಿ. ದೆನ್ ಫೈಲ್ಡ್
So you were a complainant. You were a complainant.
ನೈಬರು ಕಂಪ್ಲೇಂಟ್.
ಹಾ.
ಆಮೇಲೆ ದೆನ್ ಏನಾಯ್ತು ಅಂದ್ರೆ ಕಂಟೆಂಪ್ಟ್ ಹಾಕಿದ್ದೆ, ಯಾರು ಒಬ್ಬೇ ಮಾಡಿದ್ದಾರೆ.
ಹಾ.
ಕಂಟೆಂಪ್ಟ್ ನಲ್ಲಿ ಅವರು ಒಂದು ಡಿಫೆನ್ಸ್ ಅಂದ್ರು, ಅವ್ನು ಸೂಟ್ ಹೋಗ್ಬಿಟ್ಟು ಒಂದು ಸೂಟ್ ನಲ್ಲಿ ಸ್ಟೇ ತಂದಿದ್ದಾನೆ,
ಆಯ್ತು.
ಅದಕ್ಕೆ ನಾವು ಆಕ್ಷನ್ ತಗೊಂಡಿದ್ದಾನೆ.
Yes.
ಮತ್ತೆ ಆ ಸೂಟ್ ನಲ್ಲಿ ಹೋಗಿ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಆಗಿದೆ, ಅದು ಎಕ್ಸ್ಟೆನ್ಷನ್ ವೇಕೇಟ್ ಆಯ್ತು.
ಹಾ.
ಇದು ಆ ಸಿವಿಲ್ ಕೋರ್ಟಿಗೆ ಪವರ್ ಬರುತ್ತೆ.
ಹಾ.
ಅದಾದ್ಮೇಲೆ ನಾನು ಈ ರಿಕ್ವೆಷನ್ ಮತ್ತೆ ಪ್ರೆಸ್ ಮಾಡಿದೆ. ಅವಾಗ ಮತ್ತೆ ಒಂದು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದು ಅವ್ರು 5-8 ಏನು ವಿ ಹ್ಯಾವ್ ಗಾನ್ ಇನ್ ಅಪೀಲ್ ಟು ದಿ ಚೀಫ್ ಕಮಿಷನರ್ against that order of ordering.
So order of confirmation has been passed. So ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊಂಡು
Then he filed an appeal. ಆ ಅಪೀಲ್ ನಲ್ಲಿ ಸ್ಟೇ ತಗೊಂಡಿದ್ದೀನಿ ಅಂತ ಹೇಳಿ ಮತ್ತೆ ಆ ಅಪೀಲ್ ನಲ್ಲೂ ನಾನು ಹೋಗಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ಮೇಲೆ ಅದು ಸ್ಟೇ ಹ್ಯಾಸ್ ಬಿನ್ ವೇಕೇಟೆಡ್.
ಹಾ.
Now nothing is there. ಇಲ್ಲಿ ತೋರಿಸ್ತೇನೆ, ನಾ ಹಾಜರ್ ಮಾಡಿದ್ದೇನೆ, ವೇಕೇಟ್ ಆಗಿತ್ತು.
ಕೊಡ್ರಿ.
ನೋಡ್ರಿ ಎಲ್ಲಿದೆ ಆರ್ಡರ್, ಏನಿದೆ ಇನ್ನೇ ಆರ್ಡರ್ ಇದೆಯಾ?
What direction are you seeking in this IA?
Take up the
Same prayer.
ಹಾ.
Whatever is the main prayer, the same prayer you are making in the application. ಹಾ. ಹಾ.
ಅದನ್ನೇ ಒಂದು ಸ್ವಾಮಿ
Order status quo till then.
15/4
Sir, the appeal has to be heard and disposed of.
ಅಲ್ಲ 15/4/23 ಆರ್ಡರ್ ತಾವು ನೋಡಿ, ಅದರಲ್ಲೇ ಆರ್ಡರ್ ಶೀಟ್ ನೇ
ಹಾ.
15/4/23
ಹಾ.
ಕೇಸ್ ಕಾಲ್ಡ್
Advocate for appellant absent.
absent, applicant
Appellant present.
advocate KS for impleading present. The impleading application is
Perused.
on a demolition order. It is the BBMP authorities were to determine this so violation of the complaint. Therefore, impleading applicant is not necessary party after counter. Well, is made, hence
Is disallowed.
ಅಲ್ಲ impleading
Hence, the impeding application is disallowed.
ನನ್ನನ್ನು disallow ಮಾಡಿ ಸಂತೋಷ. ಆಮೇಲೆ ಏನ್ ಬರ್ತದೆ, the applicant requested for date as control. The interim condition, the application for is rejected for extension. Rejected. ಇದ್ರ ಮೇಲೆ ಅಲ್ಲ ಒಂದ್ ನಿಮಿಷ, 15/4 ಅಲ್ಲಿ ಇಂಟೀರಿಯಂ ಪ್ರೇಯರ್ ರಿಜೆಕ್ಟೆಡ್. ರಿಜೆಕ್ಟ್ ಆದ್ಮೇಲೆ ಇದ್ರ ಮೇಲೆ ಅವರು they have not agreed and they have not filed any appeal or requisition. 15/4 ಅಲ್ಲಿ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ಮೇಲೆ ಮತ್ತೆ ಹೇಗೆ ಮತ್ತೆ ಫ್ರೆಶ್ ಕೊಟ್ರೆ ಫ್ರೆಶ್ ಸ್ಟೇ ಕೊಡ್ಬೇಕು. ಕೊಟ್ರೆ ನನ್ನನ್ನು ಒಳಗ್ ಬರಬೇಡ ಅಂತ ಇಂಪ್ಲೀಡಿಂಗ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರು. ಆನಂತರ ಆಮೇಲೆ ಅವರೇ ಅಪಲೆಂಟು ಮತ್ತು ಚೀಫ್ ಕಮಿಷನರ್ ರಿಪ್ಲೈ continued maintain status quo ಅಂತ ಹ್ಯಾಕ್ ಮಾಡಕ.
Sir, how can we say that even before the appeal is decided, they will be permitted to go and demolish it?
ಅಲ್ಲ ನಾನು ಇಂಪ್ಲೀಡಿಂಗ್ ಹಾಕಿದ್ದೆ ಕನ್ಸಿಡರ್ ಮಾಡಿ
ಅದು ಬೇರೆ ವಿಚಾರ.
ನನ್ನನ್ನು ಕನ್ಸಿಡರ್ ಮಾಡಬಹುದಾಗಿತ್ತು.
ಬರೋದಿಲ್ಲ ಸರ್.
ಅಲ್ಲ ನನ್ನನ್ನು ಕನ್ಸಿಡರ್ ಮಾಡಬಹುದಾಗಿತ್ತ? ನನ್ನನ್ನು
The prayer in this writ petition is
ಅಲ್ಲ ಸ್ವಾಮಿ, ಇದೊಂದು ಒಂದು ಪಾಯಿಂಟ್. ಇನ್ನೊಂದು
to
ಈಗ
issue a writ of mandamus
ಲಕ್ಷ್ಮಿ ಕೈಲಿ ಕನ್ಸಿಡರ್
directing response number 1 to 4 officers of the Brihat Bengaluru Mahanagara Palike to take action against
ಅಲ್ಲ ಇನ್ನೊಂದು ಒಂದು ನಿಮಿಷ ಒಂದು ಸಬ್ಮಿಷನ್ ಮಾಡಿ
for and proceed to demolish the illegal construction of the building put up by response number 5 to 8 in the neighboring property belonging to petitioners.
ಇನ್ನೊಂದು
Full
ಸಬ್ಮಿಷನ್
stop. Next para.
ದಯವಿಟ್ಟು ಕೇಳಿ.
Learned counsel for the contesting respondents submit that the contesting respondents have preferred an appeal in appeal number 189 of 2022 before the chief commissioner, who is also the appellate authority, in respect of an order of confirmation passed by the competent authority under section 248(3) of the BBMP Act, 2020. Full stop. Learned counsel submits that the appellate authority has directed in its interim order dated 29/4/2023 that status quo shall be maintained till then. Full stop. Even otherwise, comma, it is submitted that before the appeal could be considered by the appellate authority, it is not permissible for the petitioner to seek demolition of the building. Full stop. Next para. There is substance in the submission of the learned counsel for the contesting respondents. Full stop. Since the appeal filed by them is pending consideration before the chief commissioner, comma, the petitioners have to await the result of the appeal. Full stop. If the appeal is dismissed, the chief commissioner would himself direct the assistant executive engineer or the competent authority to proceed to implement the confirmation order. Full stop. In that view of the matter,
1 second, in 1 second.
comma, the prayer
One
made by the
submission.
petitioners in this writ petition cannot be considered.
One
Yes.
submission ಏನಂದ್ರೆ ನನ್ನ ಇಂಪ್ಲೀಡಿಂಗ್ ವಜಾ ಮಾಡಿದ್ರು ನಾನು ಅಲ್ಲಿ ಹೋಗ್ ಬರಲ್ಲ 2 ವರ್ಷ ನಡೆಯುತ್ತೆ ಗೊತ್ತಿಲ್ಲ ಅಟ್ಲೀಸ್ಟ್ ಪರ್ಮಿಟ್ ಮೀ ಟು ಅಪಿಯರ್ ಬಿಫೋರ್ ದ ಚೀಫ್ ಕಮಿಷನರ್ I am a aggrieved person because on my complaint this order has been passed. I may be permitted to.
ಈಗ ಅದನ್ನ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
ಹೌದು ಅದೇ ತಪ್ಪಲ್ಲ.
You question it in a manner known to law. You are not questioning that one here.
ಅಲ್ಲ ನನಗೆ ಅವರು
How can a direction be given? No, you.
ಅಲ್ಲ ನಾನು ಯಾಕಂದ್ರೆ ವೆಕೇಟ್ ಮಾಡಿರಲ್ಲ ಇನ್ನೇನು ಉಳಿಲಿಲ್ಲ ಅಲ್ಲಿ ಅಪೀಲ್ ನಲ್ಲಿ ಮುಂದೆ ಯಾವ ತರ ಡಿಸೈಡ್ ಮಾಡ್ಲಿ ವೆಕೇಟ್ ಮಾಡಿದ್ಮೇಲೆ ನಾನು
If you still want to challenge that one, you please challenge it. Otherwise, you avoid the outcome of the appeal. Next para. Consequently, the writ petition stands disposed of. What is the amount outstanding?
1 lakh.
Huh? ಏನ್ ಮಾಡ್ತೀರಿ?
1,76,000.
ಏನ್ ಮಾಡ್ತೀರಾ?
I don't have proper instructions from the parties.
So non-compliance of the interim orders, the writ petition will have to be dismissed.
Week's time may be granted, my lord. I will seek necessary. As final, 1 week time may be granted as finally.
Ilri, before 1/6/2023, you were required to deposit 6 lakhs. ಮತ್ತೆ
Finally, a chance may be given.
automatically ಹೋಗ್ಬಿಟ್ಟಿದೆ. In terms of that order, if the said sum of rupees 2 lakhs is not deposited by 30/3/2023, the interim order will stand automatically vacated. If the balance amount of 4 lakhs is not deposited by 1/6/2023, the interim order stands vacated automatically. ಆಗೋಗಿದೆ. ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ. ಏನ್ ಪ್ರಾಪರ್ಟಿ ಮಾರ್ಗೇಜ್ ಮಾಡಿದ್ದೀರಾ? How did you take agricultural property as mortgage? For business purpose.
Yes, for business purpose, they borrowed loan.
Hmm.
Giving this
A commercial transaction, agricultural lands are not supposed to be taken as mortgage. ಇಷ್ಟು ಸ್ಮಾಲ್ ಅಮೌಂಟ್ ನೀವು ಮ್ಯಾನೇಜ್ ಮಾಡಕ್ ಆಗ್ತಾ ಇಲ್ಲ ಅಂತಂದ್ರೆ ಏನ್ರಿ?
Necessary instructions.
What can I do? See, the order is that it automatically stands vacated. ಆಗೋಗಿದೆ ಅದು by efflux of time. At the request of learned counsel for petitioner, release this matter on 28th of June 2023. We'll stop. In the meanwhile, the petitioner is able to comply with the directions issued by this court earlier, the same may be reported. Yes. If the petitioner is not able to comply with the directions issued by this court, this court will have no other option than to dismiss the writ petition.
Rain for weeks time. The office of several office objections have to comply. Some personal inconvenience.
Last time 2 weeks put it well, right?
Some personal inconvenience. A week's time.
Finally, a week's time is granted at the request of learned counsel for petitioner for complaints of office objection. We'll stop. Release this matter on 21st of June 2023. We'll stop. If office objections are not complied, the writ petition will be dismissed.
The last application is the last application where this court has directed the learned friend who is appearing for the BBMP to verify with regard to the representation given by this petitioner. It is annexure D, page 35. Because the fourth respondent is constructing the building without any plan or license. Annexure H, page 41.
Order ಏನilla.
And orally instructed. I'm not verify ಮಾಡಕ್ಕೆ ಹೇಳಿದ್ದೆ.
List this matter after service of notice on respond number 4.
Date put it because for the not kindly see annexure H at page 41.
Let us say yes.
My lord, serial number 29, my lord, I appear for respondents number 2 and 3 BBMP.
Somesekraya.
BBMP report ಹಾಕ್ಬೇಕು.
ಏನ್ರಿ ಅವ್ರ ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ರೆ then
ಆಫೀಸ್ ಆಪರೇಷನ್ ಕಂಪ್ಲೇಂಟ್
both of you will be in trouble. ಅವ್ರು ಹೇಳ್ತಾ ಇದಾರೆ ನೀವು ಅದೇ ತರ ಕಟ್ಟಿದ್ದೀರಾ ಅಂತ. We will direct the BBMP to find out whether
password. Quota number 20.
Password.
The BBMP advocate has taken time to seek inspections.
The complainant.
And the complainant seeking mandamus and cancellation of the sanction plan in respect of the response.
Why cancel?
As per the PDF plan, it is a residential area. And they have taken plans for commercial cum residential and they are proposing to build a paying guest house.
So I had pointed out that you will have to make submissions with reference to the zonal regulation. Isn't it?
I have produced a photo. Yes, my lord.
Zonal regulations, whether it is possible or permissible to permit a portion of the construction for usage of commercial purpose in a residential area. ನೀವು zonal regulation ನೋಡಿ submission ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದೆ ನಾನು last time.
Yes, sir. It is only BBMP short time to seek instructions.
Yes.
Legal construction, it was taken. In this case, that submission is not.
Correct. Yes. Yes.
It's clearly said that the length of the road is 40 feet and not 30 feet.
No, there is some basis for that contention that if the road width is so much,
Yes.
it is permissible for the BBMP, which is the provision, sir. That is why I am asking both of you. Please point out the provision first.
My first priority is mandamus.
Kodi. You are making submissions without even pointing out to the provision of law. The provision of law itara ide. Our contrary to that, they have sanctioned the plan. Antana helbek ನೀವು. Just because you raise an objection, it can be considered, is it?
My first
So
priority.
it should be with reference to a provision of law. Please point out the provision of law.
My first priority is with respect of mandamus.
Prayer alri, ಮತ್ತೆ ಅದೇ ಹೇಳ್ತಿರಲ್ರಿ. You are seeking to raise an objection that the BBMP could not have sanctioned the plan permitting establishment of a commercial shop in a residential area because the road size is so much. Which is that provision?
Kindly pass on.
Grounds raise ಮಾಡಿಲ್ಲ ನೀವು.
Madam,
Please point out from the grounds.
Row number 8.
Yes.
The petitioner submitted respondent 4 to 6 have constructed the toilets to the construction worker on frontal
Provision of law.
of commercial residential hostel building, actual usable road width should be 12 meters. And exact provision I have not mentioned.
ಮತ್ತೆ? You don't even know what is the provision.
Zonal regulation, not nothing.
Then how did you draft this writ petition, sir? How did you raise the objection then? Huh? Without even reference to the provision of law, how did you raise the objection that it is not permissible for the BBMP to have sanctioned this plan anta?
My submission.
Yes, according to you, what is this? Yes.
As per the plan.
Yes. Yes.
Please come to 4.1.2. Permissible land uses.
Hmm.
Main land use R&D. The next page, what is R&D? Ancillary land use category C2, I2, and U3. This is the next page. Where I said C2, commercial uses. Even in the residential locality.
No. There any reference to ಇದೆಯಲ್ಲ? If the plot size is
Yes.
other, you will have to first point out to that requirement.
Irrespective of what is the residential, what is the plot size, please have a look at this.
Yeah. Huh?
Up to 360. Figure number 1. Plot size square meters. Next to ground coverage is 75%. FAR is 1.75.
So the road width also is given there.
Yeah, the road width is up to 12 meters.
Yes.
In this case, what my learned says is the width of the road is only 9 meters as opposed to 12 meters. Now, they permit the not. This is the HSR PDA sanction layout plan. where the BDA layout plan says that the width of the road is 12 meters and not 9 meters. You see, this is contention. Page.
This is one nimisham. Ancillary use is allowable to 20% of the total built up area or 50 square meters, whichever is higher.
And what are the ancillary uses?
If the plot size is more than 240 square meters, having a frontage of 10 meters or more, and the abutting road is more than 18 meters in width, then ancillary use can be used as main use. Now you fall under which category?
The one which is previous, because but the road is not more than, in our case, the width of the road is 12 meters and not 18 meters.
Yes. So only 20%.
Yes, 20% of the width of it. Yes.
So they have only permitted 20%.
20%. And according to the width of the road is 9 meters and not 12 meters. According to the but the BDA layout plan clearly says that the width of the road is 40 meters. Therefore, the sanction plan is in accordance with law.
No, even otherwise, up to 12 meters. It says up to 12 meters.
It can be used as a main use. So if the width of the road is 18 meters. Now it is 12 meters. Because the ancillary use cannot be considered to be 20% can be used for commercial purposes.
Not necessary. Not necessary. It only says ancillary use is allowable to 20% of the total building built up area or 50 square meters, whichever is higher. But there is nothing saying that is permissible only if the width of the road is so much. This is table talks only of the FAR.
On submission, madam,
Yes.
my first prayer is regarding mandamus in not considering my representation on lecture A1 and A2. They are putting constructions violating the building plan also. My first prayer is for mandamus, not considering it. Second prayer is cancellation of the. So BBMP was asked to whether there is any action taken.
We'll direct them to take action if there is any deviation from the sanction plan. Aste. Therefore,
Produced the photographs also. They are demolished my.
According to your bylaws, your officers are required to make an inspection after excavation to find out whether the foundation is going to be put in terms of the sanction plan. Now they have put up a foundation, isn't it? Excavation.
Photos may kindly be seen. It starts from annexure page number 57. Tape it to photos.
Annexure A1 and A2. Please have a look at page 20. What is the prayer made by him?
57.
A1.
57 at the bottom.
Representation at page 50.
Compound ಹಾಕಿದ್ದಾರೆ.
ಆಮೇಲೆ ನಾನು ಟೇಪ್ ತಗೊಂಡು ಇನ್ನೊಂದು ಪೇಜ್ ನಂಬರ್ 59 ಎಲ್ಲ ಗೊತ್ತಾಗುತ್ತೆ. My adjacent site ನಾನು ಕಾಂಪೌಂಡ್
Correct. ಇವಾಗ excavation ಮಾಡ್ತಾರೆ ಇವಾಗ. They will ensure that the construction will be in accordance with the sanction plan.
Because this is what we said. Sought to with respect to annexure A1 and A2. Annexure A1 page 20.
No, that will be rejected. That prayer will be rejected in view of your pointing out to the provision of law that there is nothing wrong in the BBMP sanctioning the plan.
Mandamus he has sought for is to for a representation directly to the corporation to consider whether the sanction plan given to is right.
Correct, sir. That prayer will be rejected. Having noticed the provision of law, the only other prayer will be to ensure that the construction is made in accordance with the sanction plan. we will direct them to inspect timely as per the provisions of law and ensure that the construction is in accordance with
The petitioners is a vacant site, my lord. The demolish my compound wall also, entire compound wall, one.
Adu
side,
bere.
that side demolish.
Damages go to the civil court.
Not if you have taken a photograph, they are not prima.
Damages for that you will have to go to the civil court.
That they are not.
This court is not going to assess the damages.
I'm not seeking damages, my lord. I put up construction by demolishing my compound wall and they are not given any setbacks, they have laid the foundation.
ರೀ ಎಕ್ಸ್ಕವೇಷನ್ ಮಾಡುವಾಗ ಸ್ವಲ್ಪ ಜಾಸ್ತಿನೇ ಮಾಡಬೇಕು. ಎಷ್ಟಕ್ಕೆ ತೋರಿಸಿದಾರೋ ಅಷ್ಟಕ್ಕೆ ಮಾತ್ರ ಎಕ್ಸ್ಕವೇಟ್ ಮಾಡಕ್ ಆಗಲ್ಲ. Why are you so in such a great hurry?
Yes, my lord. The strict directions
Yes.
will be given to comply with the sanction plan.
The petitioner is aggrieved of the action of the respondent authorities of the BBMP in sanctioning a plan for construction of a residential and commercial building in favor of the contesting respondents number 4 to 6. 4 to 6. Stop. The prayer in the writ petition is we issue a writ of mandamus directing respondents number 1 to 3 to consider the representations given by the petitioners comma to direct them to cancel the sanction plan and pass appropriate orders. Stop. It is evident from the pleadings that the respondent BBMP has sanctioned a plan in favor of respondents number 4 to 6. Stop. However, no specific grounds are made out in the writ petition, pointing out to the relevant provisions of law to state that the BBMP authorities could not have sanctioned the plan in contravention of any of the provisions of law. So, on the other hand, learned counsel for the contesting respondents has taken this court through the zonal regulations annexed to the revised master plan 2015, Bangalore. Stop. Learned counsel submits that admittedly the property in question is in a residential area. Stop. However, provision is made in the zonal regulations that in a residential, practically main close area, ancillary use is allowable to an extent of 20% of the total built up area or 50 square meters, whichever is higher. Stop. Learned counsel submits that there is no reference to the width of the road for seeking permission to use 20% of the building for commercial purpose. Stop. That being the position, no fault can be found in the action of the respondent BBMP in sanctioning the plan permitting 20% of the building to be used for commercial purpose. Full stop. Next para. Learned counsel for petitioner submits that the contesting respondents are proceeding to excavate the site for putting up construction, and they have already violated the sanction plan. Stop. The submission of the learned counsel for petitioner cannot be accepted, since on perusal of the material available on record, it is clear that the excavation activity was not started when this writ petition was filed. Stop. Photographs produced by the petitioner shows that there is a vacant site. Stop. However, learned counsel for the contesting respondents submits that the excavation activity has commenced. Full stop. Next para. In that view of the matter, the prayer made by the petitioner to direct the respondent authorities to cancel the sanction plan is rejected. Full stop. However, the respondent officers of the BBMP are directed to inspect the property in question at the intervals as required under law and ensure that the construction which is commenced by the contesting respondents will be in accordance with the sanction plan. Full stop. Ordered accordingly.
Petitioners.
Better legible copy of A35.
A35 is one of the safeties belonging to the petitioner. Like in page 380 is where that document is. 80. So this thing is relevant, my lords. The only this thing is the site number and the schedule is what I am basing my case on. It is very well legible and decipherable from the petition. As far as the schedule is concerned, I think page 388. Very much clear, my lords. Legible.
Office objection is overruled.
Please.
Yes.
Petitioners herein are the category of unreleased site owners in respect of the layout developer respond number 4 partnership. This particular sanction was being done by respondent number 2. Sanction plan is at annexure B in page 390.
Annexure
B in page 390. Just got an extra copy of
Told.
this plan was sanctioned 2010-2005 for a site of 315 sites. Then thereafter, what happens? This respondent number 4 does not adhere to the sanction plan. So, in terms of section 17 of the Town Planning Act, only 60% of the sites comes to be released. Remaining 40% wherein the petitioner sites are stand unreleased. And there is no any basis on what is the 60% and the 40% that has been arranged. And I have given my representation, my lords.
That is the way the authorities work. Initially, they don't release all the sites together. They release only a part of the sites, and time is given to ensure that the entire formation of the layout is completed. Only after the completion of all the works, the balance sites will be released. That is how they are required to work.
At annexure F 406 of 430. The Limited submission before this particular.
Learned HCDP takes notice for respondent number 1. Learned counsel, ಈ PMRD ಯಾರು ಅಪೇರ್ ಆಗ್ತಾರೆ? ಯೋಗೇಶ್ ಡಿ ನಾಯಕ್ ಅಪೇರ್ ಆಗ್ತಾರಾ PMRD ಗೆ? ನೋಡ್ರಿ BMRD Learned counsel Shri Yogesh D Naik is directed to take notice for respondent number 2. Issue emergent notice to response number 3 and 4. Learned counsel for the petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on learned counsel for respondent number 2 and a copy on the learned AGA. ವಾಪಸ್ ಕೊಟ್ಟಿರೋದು.
ರಿಟ್ ಆಫ್ ಮ್ಯಾಂಡಮಸ್ ನಿನ್ನೆ ಹ್ಯಾಂಡ್ ಸಮ್ಮಿಟ್ ತಗೊಂಡು ಇವತ್ತು ಬೆಳಿಗ್ಗೆ ಕೊಟ್ಟಾಗ ರೆಫ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ. ಇನ್ನು ಅಕ್ಲಾನ್ಮೆಂಟ್ ಒಂದು ಎಲೆಕ್ಷನ್ ಪಿಟಿಷನ್ ಮೇಲೆ
At the request of learned counsel for petitioner release this matter on 21st of June. Yes.
Please, my lords, 33, my lords, is a connected petition which your lordships are pleased to dismiss yesterday, my lords. The Devarayandur case connected.
Learned AGA takes notice for response number 1 to 4. ಇದಕ್ಕೆ ಯಾರು ಅಪೇರ್ ಆಗಿದ್ರು?
ನಾಗರಾಜಪ್ಪ ಅವರಾಗಿದ್ರು.
ಟೆಂಪಲ್ಗಾ?
ಇಲ್ಲ, ಟೆಂಪಲ್ಗೂ AGA ಆಗಿದ್ರು. ಫಾರ್ ಗ್ರಾಮ ಪಂಚಾಯತಿ ನಾಗರಾಜಪ್ಪ ಅವರಾಗಿದ್ರು. ಚಂದ್ರಚೂಡ
ಓನ್ಲಿ ಪ್ರೆಸಿಡೆಂಟ್. ಮಿಕ್ಕಿದವ್ರಿಗೆಲ್ಲ ನಾಗರಾಜಪ್ಪ ಅವರ. Learned counsel Shri A. Nagarajappa is requested to take notice for response number 5 to 7 and 9.
Please.
Learned counsel Shri Chandrachuda, MB Chandrachuda, who is present in the court, takes notice for respondent number 8. Stop. You already ವಾಪಸ್ ಅಲ್ಲ. Learned counsel for petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on learned counsels for respondent number 8, and 5 to 9, and a copy on the learned AGA. Full stop. Release this matter on 21st of June.
Please.
Just producing for recovery. Petitioners for employees of the society. If they say there's some vouchers, there's misappropriation of 3,50,000. We sent the vouchers are with the society. Last time, it was vehicle.
AGA. ಬಂದಿದ್ಯಾ? ಏನ್ vouchers?
I am the cashier. I am not in charge of the cash account. Accounts ಮಾಡೋದು ನನ್ನ ಕೆಲಸ. The managing director was in charge of the day-to-day affairs of the society. Only at the time of inspection, he has gone on vacation and he was transferred. Vouchers and the handing over charge was not done. It was the taking over by the one more managing director. And the administrative committee has passed a resolution that the managing directors are in charge, who has misappropriated the funds. The annexes are continuing. And the vouchers which are there, we filed a application, produce those vouchers. They said that we are unable to produce them. So it is against them. The vouchers are still, we say that the present manager is no more. The first petitioner who was in charge of it. Now the second petitioner who is accounted now who is continuing this. Suddenly, vouchers they have not produced. And the order was there because the cooperative society in a dispute. They have not produced. They filed a memo stating that it is not available and then it is not.
No, but she is saying, you please go through that one.
On their application for first respondent and director. The observation that is made by the first respondent in the issue.
It is
Whatever the receipts
only
has been produced before the
vouchers are not
after
produced.
going through all the documents, only the award has been passed directly. The award has been confirmed.
Both the authorities with regard to the and the first objection was the party was examined. He was a board of clerk who has been examined. He has no authority. There is no resolution passed. Even the other on the class examiner, he says the vouchers are still with the society. Class examination. And ಅವ್ರಿಗೆ ಬೇರೆ ಏನ್ ಕೇಳಿದ್ರು I don't know. ನನಗೆ ಗೊತ್ತಿಲ್ಲ. And storekeeper has been examined. I don't know why, how they, and he has no authority also. Resolution ಕೊಟ್ಟಿಲ್ಲ. And resolution produce ಮಾಡಿರೋದು. It says that he can only appear on behalf of the which have produced as annexed to this. ಅವ್ರು ಏನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ. ಇವತ್ತು what all the we have discussed, it has been discussed by both the authorities and said that no, it has been proved ಅಂತ ಹೇಳ್ಬಿಟ್ಟು. And ಇದು even the balance sheet, only one paper of the balance sheet has been produced. We disputed it, and which has been entered after the dispute was pending. The entire, they have not examined the auditor or the who has prepared the balance sheet. Make a synopsis.
So there are 2 orders or 3 orders here.
2 orders against the cashier and the accountant. I am the accountant.
ಅದಲ್ಲ. Orders of the authorities. ಎಷ್ಟು ಆರ್ಡರ್ ಇದೆ?
That is annexure A and B.
ಎರಡೇ.
Annexure is KT, which is discussed. ಏನ್ ಹೇಳಿದೀವಿ ಅದನ್ನೆಲ್ಲ ಹೇಳ್ಬಿಟ್ಟು.
And there are concurrent findings.
Concurrent finding is there, but there is no discussion. KT order ನನ್ನ take it only in the end. Last page. What has been stated has been called out in the 57 page.
Petitioner number 1 is no more.
Please. He is no more.
There was a direction for recovery of amount from him. So you have not proceeded. Interim order here. Interim order of stay. Yes. Yes, what do you want to do now?
They will prepare a synopsis and
Learned AGA submits that the original records have been secured from the second respondent deputy registrar of cooperative societies. Full stop. Learned counsel for the petitioner seeks for a short accommodation to go through the original records and then make a submission. Full stop. Release this matter on 21st of June. 22nd. Yes. Passport matter.
And they have WP 11,978 of 23. Please, the petitioner was an elected director of Shumogga DCC Bank. 11,978. He was, an order of disqualification was passed against him. That was challenged before this court, making allegations. Interim order of stay was granted. An appeal was preferred by the state. They did not get any relief in the appeal. What they did was they conceded that order may be set aside and matter may be remanded. So WP was allowed, order was set aside and matter was remanded. Again, the authority passed an order of disqualification on 14/10/2020.
Which number?
Order model. Now only date is relevant. 14/10/2020. Against that, I preferred a writ petition. It was rejected on the ground of alternate remedy. A writ appeal, same order was confirmed. Then I preferred the appeal before the authority. Authority has now allowed my appeal, setting aside the order of disqualification. After setting aside of the order of disqualification, I issued a notice to the DCC Bank pointing out, now that order of disqualification is set aside, I am entitled to continue as a director. As regards precedent, there is some controversy, but that is another aspect. I said, I am entitled to continue as a director because the term of the DCC Bank is almost it is for another 1 more year. Then the managing director by himself issued an endorsement saying, no, earlier there is a co-option made. Therefore, you cannot become a director even if your appeal is allowed. On 2 grounds, he issued the petitioner initially was elected as a director of a TAPCMS. From TAPCMS, he was elected to DCC Bank as a director. In the normal course, if there was no disqualification order, in the normal course, as a director of TAPCMS, my term would have come to an end on 23/5/21 unless I was re-elected by that time. During pandemic, election was not held to the TAPCMS. Ultimately, election was held to TAPCMS on 24/1/23. Petitioner was duly elected as a director of TAPCMS also. Now, what they did was, when I was disqualified and interim order was not granted in my favor, they intimated the election commission that the vacancy has occurred, election is required to be held. Kindly see annexure J, page 47. Election authority issued a direction to hold the election, and as per annexure J1, they fixed the date of election also, 29/5/21. At this time, the second pandemic this thing came. Therefore, this was
Again postponed.
The election was not held. At this stage, they passed a resolution co-opting the respondent annexure H. Under annexure H, dated page 41, 16/11/2021. They co-opted one Mr. Gururaj, whom I have implemented as respondent number 7. On, your lordship may kindly notice, the resolution is dated 16/11/21. It is supposed to be under section 29E, and communication annexure H1 is dated 26/11/21.
So that is not only in respect of one director.
No, in respect of only one
Only
seat.
one director.
Only one seat. They co-opted, it is not election. for vacancy, they co-opted. Now, these 4 dates will be relevant, my lord. Election to DCC Bank was held on 6/5/2019. In the normal course, 5 years term will expire in 2024 May. The vacancy by way of disqualification order arose on 14/10/2020 before completing half of the term. 2.5 years agodrolage vacancy arises. A vacancy, they reported it as vacancy. Election was announced, but election was not held. In the meanwhile, a co-option is made. Now they want to claim that even if you were not disqualified, in the normal course, TAPCMS election was not held on 23/5/21. Therefore, on that date, you would have ceased to be a member. Therefore, even otherwise, even if you have succeeded in the appeal, you will not get the term, is what they want to, the managing director has said. Now, your lordship may kindly see section 29, capital E. Any vacancy in the office of members of the board of a cooperative society by reason of death, resignation, removal, or otherwise shall be filled up in such manner as may be specified in the bylaws of such society, provided that cooperative election authority shall conduct the election to fill up any vacancy in the office of the director of the board if the remaining term of office of the board is more than half of its original term. Illi 6/5/2019 andre avruddu 20 months would have been completed. 20 months would have been completed on
ಸಿನಾಪ್ಸಿಸ್ ಮಾಡ್ಕೊಂಡಿಲ್ವ ನೀವು?
ಮಾಡಿದ್ದೀನಿ ಅದೇ that would be January 2023.
2.5 years.
2.5 years. 6/5/20, 6/5/21, January 22. January 22.
ಏನದು ಯಾವ್ದು ಎಲೆಕ್ಷನ್
ಬ್ಯಾಂಕಿನ
ಎಲೆಕ್ಷನ್ ಆಗಿದೆ ಯಾವಾಗ ಅದು?
6/5/2019.
6/5/2019.
24 or 30 ತಿಂಗಳಾಗಬೇಕು. 6/5/20, 6/5/21. ಆಮೇಲೆ November, it's actually November 2021. 5/11/2021.
Yes.
Now your lordship may kindly take these 3 dates. My disqualification was on 14/10/2020 from the DCC Bank.
Yes.
That would be prior to 5/11/21. Derivative, they say, if you were.
So it became vacant.
It became vacant.
And admittedly, there was more than 2.5 years left.
How? Before 2.5 years, ಅದು
Vacant.
ಅವ್ರಿಗೆ ಹೇಳೋದು ನೀವು ಕಂಟಿನ್ಯೂ ಆಗಿದ್ರೆ TAPCMS ಇಲೆಕ್ಷನ್ ಮಾಡದೇ ಇದ್ದಾಗ ಮತ್ತೆ ಡಿಸ್ಕ್ವಾಲಿಫೈ ಆಗ್ತಿದ್ರಿ ಅಥವಾ ಯು ವಿಲ್ ಸೀಸ್ ಟು ಬಿ ಎ ಮೆಂಬರ್ ಅಂತ that is a second contention. That arose, that vacancy would have arisen on 23/5/2021. TAPCMS Shumoga. 23/5/2021. Even that is before November 2021. So, ನಾನು disqualification suffer ಆಗದೆ ಹಾಗೆ ಕಂಟಿನ್ಯೂ ಆಗಿದ್ರು TAPCMS ಇನ ಎಲೆಕ್ಷನ್ ಆ ಟೈಮಿಗೆ ಆಗ್ತದೆ ಅಂತ ಇಟ್ಟುಕೊಂಡ್ರೆ such a derivative disqualification ceasing will not apply. But ಆವಾಗ ಸಹಿತ it was a vacancy which is to be filled. ಈಗ 29E ತಾವು ನೋಡಿದ್ರಿ ಅದರಲ್ಲಿ an amendment was made. ಸೆಕೆಂಡ್ ಪ್ರೊವಿಜೋದಲ್ಲಿ ಒಂದು ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿ provided further that board may fill up the second provision. Fill up the casual vacancy of the board by nomination out of the same class of members in respect of which casual vacancy has arisen till the election is held for such vacancy. Election authority election ಮಾಡಲ್ಲಿವರೆಗೆ this amendment was made, second proviso to section 29E. It was by Act 36 of 21. It came into force with effect from 7/10/21.
Report of sir. Very thoroughly, was it thoroughly? ಅದು 2021 ಸೇಮ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಗಿದೆ ಆಮೇಲೆ
ಫಸ್ಟ್ ಪ್ರೊವಿಜೋ ಪ್ರಕಾರ ಇಲೆಕ್ಷನ್ ಅಥಾರಿಟಿ ಅವರು ಇಲೆಕ್ಷನ್ ಮಾಡಿ ಫಿಲ್ ಅಪ್ ಮಾಡಬೇಕು ಇಫ್ ಇಟ್ ಈಸ್ ಬಿಫೋರ್ 2.5 years. ಅಕಸ್ಮಾತ್ ಫಿಲ್ ಅಪ್ ಮಾಡಿರದೆ ಹೋದ್ರೆ ಇವೆಂಚುಯಾಲಿಟಿ provided further that second provision provided further that board may fill up casual vacancy of the board by nomination out of the same class of members in respect of which casual vacancy has arisen till the election is held for such vacancy.
So it's only a stopgap arrangement.
All that I wanted to point was it is an ad hoc arrangement. Now the contention I am advancing before your lordship is this is 1992 3 SCC page 1 Chamundi Mopex. The Your lordship may kindly go to para 10. What happens if an order is quashed or set aside, etc.? In the instant case, the proceedings before the board under section 15 and 16 of the Act, that is Sikh Industrial Undertaking Act, had been terminated by the board. Order of the board dated 26/4/1990, whereby the board, upon consideration of the facts and material before it, found that appellant company had become economically and commercially non-viable due to its huge accumulated losses and liabilities and should be wound up. The appeal filed by the appellant company under section 25 of the Act against the said order of the board was dismissed by the appellate authority by the order dated 1/7/1991. As a result of these orders, no proceedings under the Act were pending either before the board or before the appellate authority on 21st February 1991. When the Delhi High Court passed the interim order staying the operation of the order of the appellate authority dated 7/1/1991, the said stay order of the High Court cannot have the effect of reviving the proceedings which had been disposed of by the appellate authority by its order dated 7/1/1991. while considering the effect of an interim order of stay, staying the operation of the order under challenge, a distinction has to be made between quashing of an order and stay of operation of the order. Next sentence is what I am relying on. Quashing of an order results in restoration of the position as it stood on the date of passing of the order which has been quashed. So, status quo as on the date of order would be restored if a final order setting aside or quashing the disqualification order is made. My disqualification order is set aside by the appellate authority on 19/5/2023 under Annexure A, page 25. Now, who can oppose saying that I will no, disqualification continues or you will be disqualified in another, etc. Is, your Lordship may kindly see another decision, 2016 2 SCC 779, Poonam versus State of Uttar Pradesh. In that, your Lordship may kindly go to para 8. In that, your Lordship may kindly turn to para 8. At the very outset, what had happened in this case was a fair play license was cancelled. Against that, the licensee preferred an appeal. Appeal was pending for a long time. In the meanwhile, the license was granted to some other party during the pendency of the appeal. In the appeal, he got himself impleaded, but appeal was allowed. The license was to be restored. This person to whom during the pendency it was granted took up the proceedings saying that it has been granted to me, therefore there is no question of my license being cancelled. That matter went before the Supreme Court. Para 8. Yes. At the very outset, we must unequivocally state that we are not required to enter into the issue whether cancellation was justified or not, or the order passed by the appellate authority allowing the appeal is defensible in the facts and circumstances of the case. Adre appellate authority order sari aiti illa annodhu nodbekada avashyakate illa. Yes. For the High Court has expressed its disinclination to enter into the said arena at the instance of the present appellate on the foundation that she was an allottee after the cancellation of allotment, who was the licensee to run the fair price shop of the fifth respondent. The learned counsel for the appellant has also rightly not advanced any argument in that regard, except emphasizing on the fact that the appellant had an independent right on her own. The High Court was under lawful obligation to address itself with regard to the legal substantiality of the order passed by the appellate authority on the touchstone of exercise of writ jurisdiction. However, on the nature of the allotment made in favor of the appellant. Be it noted, before the appellate authority, appellant had got herself impleaded after coming to know that the fifth respondent had preferred an appeal challenging the order of cancellation, and the appellate authority had considered the submission of the original allottee as well as the present appellant. The thrust of the matter is whether the appellant can be regarded as a person who is a necessary party to the list in such a situation and is entitled under law to advance the argument that the order passed by the appellate quorum being legally unsustainable, the writ court was obliged to adjudicate the controversy on merits. It's an admitted position that village Ardhuana had initially 2 shops. Shop number 2 was allotted in favor of 5th respondent. He was granted license to run the fair price shop. On the basis of certain complaints being received, competent authority after an inquiry had cancelled the license. Appellate authority after ascribing certain reasons has overturned the said order. The effect of the said order has to be that original allottee remains an allottee and his license continues. The appeal was preferred challenging the cancellation of allotment and the order of license. It is not a situation where the appeal had been treated to have become rendered infructuous on the basis of any subsequent event, such as the shop in question has been demarcated for any reserved category. In that event, such subsequent fact would have been brought to the notice of the appellate authority. And in that event, possibly no relief could have been granted by the appellate authority to appellate, except removing the stick. The stand of the state is that initially shop number 2 was attached to the other licensee, and thereafter on the basis of resolution passed by Gram Sabha, it was allotted to present appellate, though it was mentioned that it has been granted under visually impaired quota. But the character of the shop remained the same. At this juncture, it is obligatory on our part to refer to the letter circular dated so and so of the Chief Secretary, which refers to the government order dated 7/8/22 in respect of the SC, ST and reservation, other backward classes. Thereafter, there is a reference to certain horizontal reservation.
I don't think these things.
ಅದರಲ್ಲಿ ಎಲ್ಲಿವರೆಗೆ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ not only that you don't have a right, you are not entitled to challenge or claim any legal status.
The declaration of law ಅದು ತೋರಿಸ್ಬಿಟ್ರೆ ಸಾಕು.
Legal status. Kindly go to para 13. Though the narration of facts is reflective of a different contour of controversy, allotment and grant of license for a fair price shop, the seminal issue as noted here in above would hinge on the answer to the question pertaining to the right to assail the order passed in the appeal. The appellant was not impleaded as a party in the appeal, but she herself got impleaded. Assuming the appellate authority would have decided the appeal in favor of the original allottee in her absence, could the present appellant, a subsequent allottee in respect of the same shop, have been allowed in law to make grievance by invoking the jurisdiction of any statutory forum, or for that matter, High Court under Article 227 of the Constitution. In essence, whether she is a necessary party to the litigation and entitled to contest the legal vulnerability of the order of cancellation, or in any manner advance the plea that her allotment would not be affected, despite the factum that the order of cancellation of the earlier allottee has been quashed. To appreciate the said issue, we will dwell upon certain authorities, though they may pertain to different jurisprudence. Then they discuss about 3 cases, my lord, earlier cases. Kindly go to, after that, kindly go to para 70. The term entitled to defend confers an inherent right to a person if he or she is affected or is likely to be affected by an order to be passed by any legal forum. For there would be violation of natural justice. The principle of audi alteram partem has its own sanctity, but the said principle of natural justice is not always put in a straitjacket formula. That apart, a person or an authority must have a legal right or right in law to defend assay. We may first clarify that as a proposition of law, it is not in dispute that natural justice is not so and so. Its applicability to be adjudged. Even that we can leave it, my lord. Your lordship may kindly go to Your Lordship, may kindly go to para 47. We have referred to the aforesaid decisions with the purpose that the company or authority has been treated as necessary party on the foundation that it meets the criteria provided in the definition clause, and that apart ultimately it has to pay compensation. Therefore, it has a right in law to participate in the proceedings pertaining to the determination of the amount of compensation. Factual score, needless to say, stands on different footing. A few examples can be given so that the position can easily be appreciated. There are provisions in some legislations pertaining to Gram Panchayat or Panchayat Samiti, where on certain grounds the competent authority has been conferred power to remove elected sarpanch or chairman, as the case may be, on certain counts. Against the said order of the collector, an appeal lies. Eventually, either a revision or writ lies to the High Court. After his removal, someone by way of indirect election from amongst the members of the panchayat or panchayat samiti is elected as sarpanch or the chairman. The removed sarpanch assails his order of removal as aggrieved by the manner and method and the reasons for removal. In his eventual success, he has to hold the post of sarpanch if the tenure is there. The question thus arises whether the person who has been elected in the meantime from amongst the members of the Panchayat Samiti or Sabha is a necessary party. The answer has to be categorically no, for he cannot oppose the order of removal availed by the affected sarpanch, nor can he defend his election because he has come into being because of a vacancy arising arising due to different situation. In the instant case, shop in ಹೇಳಿ it is 49 ನಲ್ಲಿ placitum C the ಕೆಳಗಡೆ she would have continued to hold the shop subsequent allotment. Yes. Had the original allottee lost the appeal, she cannot assail the said order in a writ petition because she is not a necessary party. If the state or its functionaries who could have challenged the same in appeal, they have maintained sphinx-like silence in this regard. Be that as it may, that would not confer any locus on the subsequent allottee to challenge the order passed in favor of formal allottee. She is a third party to the list in this context. She will not get any right. All that I will say is, para 53 also may kindly be seen. We have referred to the said decision in Ramesh Hirachan case in extenso, as there is emphasis on curtailment of legal right. The question to be posed is whether there is a curtailment or extinction of a legal right of the appellant, subsequent allottee. The writ petitioner before the High Court was trying to establish her right in an independent manner. That is, she has an independent legal right. It is extremely difficult to hold that she has an independent legal right. Para 53. 53. Please. We have referred to the said decision in Ramesh Hirachan case in extenso, as there is emphasis on curtailment of the legal right. The question to be posed is whether there is curtailment or extinction of a legal right of the appellant, that is subsequent allottee. The writ petitioner before the High Court was trying to establish her right in an independent manner. That is, she has an independent legal right. It is extremely difficult to hold that she has an independent legal right. It was the first allottee who could have continued in law if his license would not have been cancelled. He was entitled in law to prosecute his cause of action and restore his legal right. Restoration of the legal right is pivotal and the prime mover. The eclipse being over, he has to come back to the same position. His right gets revived, and that revival of the right cannot be dented by a third party. So my respectful submission before your lordship is, in factual scenario of this case also, the endorsement annexure A proceeds on two grounds. Setting up annexure E, that is page 36.
Yes.
It's a small endorsement, but I would just read. ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖದ ನಿಮ್ಮ ಪತ್ರದಲ್ಲಿ ಈ ಕೆಳಕಂಡಂತೆ ಕೋರುತ್ತಾ ತಮ್ಮನ್ನು ಸಹಕಾರ ಸಂಘಗಳ ಜಂಟಿ ನಿಬಂಧಕರು ಬೆಂಗಳೂರು ಪ್ರಾಂತ ಸೋ ಇವರು ಮಾಡಿದ ಅನರ್ಹತಾ ಆದೇಶದ ವಿರುದ್ಧ ನೀವು ಸಲ್ಲಿಸಿದ ಮೇಲ್ಮನವಿ ಸೋ 8 ರಲ್ಲಿ ಮಾನ್ಯ ಸಹಕಾರ ಸಂಘಗಳ ಅಪರ ನಿಬಂಧಕರು ಆ ಮೇಲ್ಮನವಿ ಅರ್ಜಿಯನ್ನು ಪುರಸ್ಕರಿಸಿ 14/10/22 ಮಾನ್ಯ ಸಹಕಾರ ಸಂಘಗಳ ಜಂಟಿ ನಿಬಂಧಕರು ಬೆಂಗಳೂರು ಇವರು ಮಾಡಿದ ಆದೇಶವನ್ನು ರದ್ದುಪಡಿಸಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ತಮ್ಮ ವಿರುದ್ಧ ಮಾಡಲಾದ ಅನರ್ಹತೆ ಆದೇಶವು ರದ್ದುಗೊಂಡಿರುವುದರಿಂದ ತಾವು ಶಿವಮೊಗ್ಗ ಡಿಸಿಸಿ ಬ್ಯಾಂಕಿನ ನಿರ್ದೇಶಕರ ಸ್ಥಾನದಲ್ಲಿ ಮುಂದುವರಿಯುವ ಬಗೆಗೆ ಪತ್ರವನ್ನು ನೀಡಿ ಅದರೊಂದಿಗೆ ಅಪರ ನಿಬಂಧಕರ ಆದೇಶದ ಪ್ರತಿಯನ್ನು ಲಗತ್ತಿಸಿ ಆಡಳಿತ ಮಂಡಳಿಯ ಸಭೆಯ ನೋಟಿಸ್ ನೀಡಲು ಕೋರಿರುತ್ತೀರಿ. ಈ ಕುರಿತು ಕಾನೂನು ಸಲಹೆಯನ್ನು ಪಡೆಯಲಾಗಿದ್ದು, ಕಾನೂನು ಸಲಹೆಯಲ್ಲಿ ತಿಳಿಸಲಾದಂತೆ ಕರ್ನಾಟಕ ಸಹಕಾರ ಸಂಘಗಳ ಕಾಯ್ದೆ 18B(1) ಮತ್ತೊಂದು ಪ್ರಾಥಮಿಕ ಹಂತದ ಸಹಕಾರ ಸಂಘದ ಪ್ರತಿನಿಧಿಯಾಗಿರುವ ದ್ವಿತೀಯ ಸಹಕಾರ ಸಂಘ ಅಥವಾ ಸಂಯುಕ್ತ ಸಂಘ ಅಥವಾ ಅಪೆಕ್ಸ್ ಸಂಘದ ನಿರ್ದೇಶಕನು ತಾನು ಪ್ರತಿನಿಧಿಸುವ ಸಹಕಾರ ಸಂಘದ ನಿರ್ದೇಶಕನಾಗಿರುವುದು ನಿಂತು ಹೋಗುವ ಕಾರಣ ಅಂತಹ ಸಹಕಾರ ಸಂಘದ ನಿರ್ದೇಶಕನಾಗಿರುವುದು ಕೂಡಲೇ ನಿಂತು ಹೋಗತಕ್ಕದ್ದು ಎಂದಿರುವ ಕಾರಣ ನೀವು ಆರಿಸಿ ಬಂದ ಮಾರಾಟ ಸಹಕಾರ ಸಂಘಗಳ ಮತಕ್ಷೇತ್ರವಾದ ಶಿವಮೊಗ್ಗ ತಾಲೂಕು ವ್ಯವಸಾಯೋತ್ಪನ್ನ ಮಾರಾಟ ಸಹಕಾರ ಸಂಘ ನಿಯಮಿತ ಇದರ ಆಡಳಿತ ಮಂಡಳಿಯ ಅವಧಿಯು 23/5/21 ಮುಕ್ತಾಯವಾದ ಕಾರಣ ಅಂದಿನಿಂದ ಜಾರಿಗೆ ಬರುವಂತೆ ನಿಮ್ಮ ಸದಸ್ಯ ತನ್ನಿಂದ ತಾನೇ ನಿಂತು ಹೋಗಿರುವ ಕಾರಣ ಈ ಡಿಸಿಸಿ ಬ್ಯಾಂಕಿನ ನಿರ್ದೇಶಕತ್ವವು ನಿಂತು ಹೋಗಿರುವುದಾಗಿ ಈ ಡಿಸಿಸಿ ಬ್ಯಾಂಕಿನಲ್ಲಿ ನಿರ್ದೇಶಕರಾಗಿ ಮುಂದುವರಿಯಲು ಬರುವುದಿಲ್ಲವೆಂದು ಹಿಂಬರಾದ ನೀಡಿದೆ. 18B(1) ಖಾಲಿ ಉಳಿದ ಸ್ಥಾನವನ್ನು 16/11/21 ನಡೆದ ಬ್ಯಾಂಕಿನ ಆಡಳಿತ ಮಂಡಳಿಯ ಸಭೆಯ ನಿರ್ಣಯದಂತೆ 19/11/21 ಅನ್ವಯವಾಗುವಂತೆ BK ಗುರುರಾಜ್ ಇವರನ್ನು ಕೋಆಪ್ಟ್ ಮಾಡಿಕೊಳ್ಳಲಾಗಿದೆ. 2 things he states. ನಿಮ್ಮ ವೇಕೆನ್ಸಿ, whether this order is there or not, you would have ceased to be a member as on 23/5/2021. Therefore, on that day again vacancy arose. It is in that vacancy respondent number 7 is co-opted with effect from 19/11/21. Or with effect from 19/11/21. ಅಂದ್ರೆ 19/11/21 ಯಾಕೆ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ ಅವರು
it would fall vacant.
It would fall vacant
From which date?
ಅದು for 23/5/21. 2021. 18B(1) ಕೆಳಗೆ. If I were a director.
18B(1),
capital B(1).
Yes.
If I were a director.
But when was that person co-opted?
ಅವರು ಕೋಆಪ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದು 16/11/21.
After that.
ಅವರಿಗೆ ಈ ಕಂಟೆನ್ಷನ್ ಅನ್ನ, ಈ ಡೇಟ್ಸ್ ಅನ್ನ ಯಾಕೆ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ,
yes,
your lordship may kindly see whether it had arisen after 2.5 years or that we are doing it after 2.5 years ಅಂತ ಹೇಳೋದಕ್ಕಾಗಿ 1911 ಅಂತ. Otherwise
continue at 2:30.
Otherwise it would have been 2.5 years on 5/11/21.
ಅದು ಇದ್ರಲ್ಲಿ ಆಗ್ತಾನೆ ಇರ್ತದೆ. ಅದು ಕನ್ಸರ್ನ್ ಬಂದು 21. 29 ಸೆಕೆಂಡ್ ರಿವ್ಯೂ. ಇವತ್ತು 54 ತನಕ ಬಿಡಿದೆ. 85.
On site ಅದು ಬಂದಿತ್ತು ನಾನು ಹೇಳೋದು ನಮ್ಗೇನಿಗೆ ಬೇಕು ಎಲ್ಲ ಬರಕ್ಕೆ ಏನ್ ನಂಬರ್ Court officer. Court officer. ಏನಕ್ಕೆ ಇಲ್ಲಿಗ
Court officer. Court officer. Court officer. Court officer. Sorry, ಈಗ ಹಿಯರಿಂಗ್ ತಗೊಳ್ತೀರಾ ಅಥವಾ ಬಟ್ ಪಾಸ್ ಓವರ್ ಇದಾವ?
Sir, ಇದು continuation sir, matter. Continuation.
ಸಾರಿ ನಾನು ಕೇಳಿಲ್ಲ, ಸಾರಿ.
ಮ್ಯಾಟರ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ ಸರ್, ಇನ್ನು ಏರ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಓಹ್, ಕಂಟಿನ್ಯೂ ಆಗ್ತಿದ್ದಾರೆ ಯಾವ್ದು ಮ್ಯಾಟರ್? ಓಕೆ 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 ಓಕೆ, ಸಾರಿ.
ಇರ್ಲಿ ಬಿಡಿ ಸರ್, ಏನು ಲೈಟ್ ತುಂಬಾ ಬೆಳೀತಾ ಇದೆ. ವೆರಿ ನೈಸ್. ಸರಿ.
page 36. I was referring to page 37. Second paragraph, page 37. ಪ್ರಕರಣ 18B1 ಅನ್ವಯ ಖಾಲಿ ಉಳಿದ ಸ್ಥಾನವನ್ನು 16/11/21 ನಡೆದ ಬ್ಯಾಂಕಿನ ಆಡಳಿತ ಮಂಡಳಿಯ ಸಭೆಯ ನಿರ್ಣಯದಂತೆ 19/11/2021 ಅನ್ವಯವಾಗುವಂತೆ ಸೊ ಇವರನ್ನು ಕಾಪ್ಟ್ ಮಾಡಿಕೊಳ್ಳಲಾಗಿದೆ.
Page number
37. Page number 37.
The second page of annexure E.
Second page of annexure E. ಅದರಲ್ಲಿ ಲಾಸ್ಟ್ ಪ್ಯಾರಾ.
Yes.
ಪ್ರಕರಣ 18B1 ಅನ್ವಯ ಖಾಲಿ ಉಳಿದ ಸ್ಥಾನವನ್ನು 16/11/21 ನಡೆದ ಬ್ಯಾಂಕಿನ ಆಡಳಿತ ಮಂಡಳಿಯ ಸಭೆಯ ನಿರ್ಣಯದಂತೆ 19/11/21 ಅನ್ವಯವಾಗುವಂತೆ PK ಗುರುರಾಜ್ ಅವರನ್ನು ಕೋಆಪ್ಟ್ ಮಾಡಿಕೊಳ್ಳಲಾಗಿದೆ.
Yes.
This date they have mentioned for a reason. Reason is the.
But do you have a copy of that resolution or whatever?
I have annexure H is the resolution. Before that, my lord, the reason for mentioning these dates is this. As your lordships noticed, it would have been 5th November 2021.
Correct.
2.5 years ಮುಗೀತಿತ್ತು. ಅದಕ್ಕಾಗಿ ಇವರು 5th November ನಂತರ ಮಾಡ್ಕೊಂಡಿದ್ದೇವೆ 16/11 ಅಂತ ಹೇಳಿ 19/11 ಮೆನ್ಷನ್ ಮಾಡೋದಕ್ಕೆ ಕಾರಣ ಏನು ಅಂದ್ರೆ though election was held on 6/5/2019, ಪ್ರೆಸಿಡೆಂಟ್ ಇಲೆಕ್ಷನ್ 17ನೇ ತಾರೀಕಾಗಿತ್ತು 17/5/19. ಅದಕ್ಕಾಗಿ ಅಕಸ್ಮಾತ್ ಪ್ರೆಸಿಡೆಂಟ್ ಇಲೆಕ್ಷನ್ ಅದಲ್ಲಿಂದ 5 years ಅಂತೇಳಿ ಕೌಂಟ್ ಮಾಡಿದ್ರು 2.5 years would be over by 17/5. ಅದಕ್ಕಾಗಿ ವಿತ್ ಇಫೆಕ್ಟ್ ಫ್ರಮ್ 1911 ಅಂತ ಮಾಡಿದ್ರು. ಆದ್ರೆ ಅವು ಯಾವುದು ಇಟ್ ವಿಲ್ ನಾಟ್ make any difference for the reason the time to be counted two and a half years ಇದೆಯೋ ಇಲ್ಲೋ ಅನ್ನೋದನ್ನು ಕೌಂಟ್ ಮಾಡೋದು on the day when the vacancy arose, not on the day when you are considering the matter. ಇದು ಡಿವಿಷನ್ ಬೆಂಚ್ ನಲ್ಲೇ ಬಂತು.
But see, there are 2 dates involved here.
TBCMS ಇಂದಕ್ಕೆ ಬರ್ತೇನೆ ನಾನು ಆ ಡೇಟ್ ಇಂದು ಹೇಳ್ತೀನಿ. ಬಟ್ ಯಾವುದೇ
let us see the resolution.
ಅಲ್ಲ
if they have said this nomination is being done in terms of section 18, not because of the disqualification that arose and the vacancy arose because of the disqualification, then where do we stand?
ಆವಾಗ
Yes.
ಅದನ್ನ ಅವ್ರು ಹೇಳೋದಕ್ಕೆ ಬರೋದಿಲ್ಲ. ಯಾಕೆಂದ್ರೆ prior to that date they declared it as a vacancy, wrote to the election authority to hold election. Election authority issued a calendar of events. Fortunately for me, because of second pandemic, this thing, the election got postponed. Once they have declared it as a vacancy, they cannot now say again that vacancy has arisen in another vacancy. That question may not arise. I will take to that. But anyway, this your lordship may kindly see.
Yes.
Matter came up before the division bench, my lord.
Yes.
Page 3 dalli. The question that requires to be examined in this case is whether the remaining term of office of the board referred to in section 29 capital E of the Karnataka Cooperative Societies Act has to be computed from the date when the vacancy in the office of the director of the board occurred, or from the date of notification to fill the vacancy. The intra-court appeals are directed against the order dated 13/10/2017 passed by the learned single judge in WP so and so. We have heard so and so, Srinidhi so and so. To examine the aforesaid question, it is relevant to refer to section 29 capital E of the Act, which reads as follows. After quoting the section, a plain reading of section 29E of the Act extracted above indicates the remaining term of office of the board referred to therein has to be computed from the date when the vacancy in the office of the director of the board occurred, and not from the date of notification to fill the vacancy. There is nothing in this section to suggest to the contrary. If so computed, the remaining term of office of the board, as on the date when the vacancy in the office of the director of the board in the appellant society occurred, will be more than half of its original term. In such a circumstance, section 29E of the Act mandates holding of election to fill the vacancy of the board. Hence, we find no ground to interfere with the order passed than a single judge. Of course, my lord, there are other cases by a single judge also holding the same thing. Now that it is a division bench judgment, that would this I am bringing to your lordship's notice for the reason.
Now let us see that resolution.
Please. ಅದಕ್ಕೂ ಮೊದಲೇ ಇದನ್ನು ಒಂದು ನೋಡ್ಬೇಕು ನಾವು. Their intimation to the election authority. Kindly go to page 47. ಅದರಲ್ಲಿ ವಿಷಯ ಶಿವಮೊಗ್ಗ ಜಿಲ್ಲಾ ಕೇಂದ್ರ ಸಹಕಾರ ಬ್ಯಾಂಕ್ ಶಿವಮೊಗ್ಗ ಇವರ ಆಡಳಿತ ಮಂಡಳಿಯಲ್ಲಿ ಆಕಸ್ಮಿಕವಾಗಿ ತೆರವಾಗಿರುವ ನಿರ್ದೇಶಕರ ಒಂದು ಸ್ಥಾನಕ್ಕೆ ಚುನಾವಣೆ ನಡೆಸಲು ರಿಟರ್ನಿಂಗ್ ಅಧಿಕಾರಿಯನ್ನು ನೇಮಕ ಮಾಡುವ ಬಗ್ಗೆ ಉಲ್ಲೇಖ. ವ್ಯವಸ್ಥಾಪಕ ನಿರ್ದೇಶಕರು ಶಿವಮೊಗ್ಗ ಜಿಲ್ಲಾ ಕೇಂದ್ರ ಸಹಕಾರ ಬ್ಯಾಂಕ್ ಶಿವಮೊಗ್ಗ ಇವರ ಪತ್ರ ಸಂಖ್ಯೆ ಸೋ ಅಂಡ್ ಸೋ ಡೇಟೆಡ್ 4/3/21. So they intimated the vacancy to the election authority as required under the rules on 4/3/21 itself, saying in view of the disqualification order passed against so and so, there is a vacancy. Pursuant to the
disqualification occurred on 6/5/2019.
6/5/2019 ಆಗಿತ್ತು. ಅದನ್ನ ಇಲ್ಲಿ ಸ್ಟೇ ಆಯ್ತು. They considered, got the matter remanded. 6/5/2019 election disqualification.
ಯಾವಾಗ ಆಗಿದ್ದು ಡಿಸ್ಕ್ವಾಲಿಫಿಕೇಶನ್?
ಡಿಸ್ಕ್ವಾಲಿಫಿಕೇಶನ್ 14 ಮೊದಲಾಗಿದ್ದು
14/10.
ಹೌದು 14/10/2020. 4/3/21 ಗೆ they intimated that there is a vacancy, please hold the election.
You said there was some order of stay.
Your lordship, I kindly have this.
Yes.
14/7/2020 disqualification was made.
14/7 or 14/7?
14/7.
14/7 na?
ಅಲ್ಲ ಅದನ್ನ ಚೇಂಜ್ ಮಾಡಬೇಡಿ. 14/7/2020 ಡಿಸ್ಕ್ವಾಲಿಫಿಕೇಶನ್ ಮಾಡಿದ್ರು. ಅದನ್ನ ನಾನು ಚಾಲೆಂಜ್ ಮಾಡಿದೆ, ಸ್ಟೇ ಆಯ್ತು. ಸ್ಟೇ ಆದ ನಂತರ ಅವ್ರು ರಿಟ್ ಅಪೀಲ್ ಹಾಕಿದ್ರು. ರಿಟ್ ಅಪೀಲ್ ನಲ್ಲೂ ಏನೂ ಆಗ್ಲಿಲ್ಲ. ಆವಾಗ government considered that order is passed by an authority taking some extraneous considerations. Therefore, kindly allow the writ petition and remand the matter to be heard by a different officer. Writ petition was allowed and matter was relegated. So next time the order was passed on 14/10/2020. So disqualification order.
It was 14/7.
ಮೊದಲೇ 14/7 ಮಾಡಿದ್ರು. ಸ್ಟೇ ಆಯ್ತು. ಅದು ಸೆಟ್ ಅಸೈಡ್ ಆಗಿ ರಿಮಾಂಡ್ ಆಯ್ತು. 14/10/2020 ಗೆ ಮತ್ತೆ ಆರ್ಡರ್ ಆಯ್ತು. ಇದರಲ್ಲಿ ಸ್ಟೇ ಸಿಗ್ಲಿಲ್ಲ. there was no interim order. 14/10 ನಲ್ಲಿ ಆದ ನಂತರ there was no interim order. ಇವರು 4/3/21 ಗೆ ವೇಕೆನ್ಸಿ ಅರೈಸ್ ಆಗಿದೆ, ನಾವು ಇಲೆಕ್ಷನ್ ಮಾಡಬೇಕು ಅಂತ ತಿಳಿಸಿದ್ರು. ಆನ್ 10/3/21 ಮೇಲ್ಕಂಡ ವಿಷಯ ಮತ್ತು ಉಲ್ಲೇಖಗಳಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ವ್ಯವಸ್ಥಾಪಕ ನಿರ್ದೇಶಕರು ಸೊ ಅಂಡ್ ಸೋ ಇದರ ಆಡಳಿತ ಮಂಡಳಿಯಲ್ಲಿ ಆಕಸ್ಮಿಕವಾಗಿ ತೆರವಾಗಿರುವ ನಿರ್ದೇಶಕರ ಸ್ಥಾನಕ್ಕೆ ಚುನಾವಣೆ ನಡೆಸಲು ರಿಟರ್ನಿಂಗ್ ಆಫೀಸರ್ ಅವರನ್ನು ನೇಮಿಸಲು ಕೋರಿರುವುದರಿಂದ ಉಲ್ಲೇಖ 2ರ ಆದೇಶದಂತೆ ಆದೇಶ ಹೊರಡಿಸಿದೆ. Election authority appointed returning officer on 10/3/21. He issued calendar of events. Next page, page 49. Page 49 ನಲ್ಲಿ calendar of events issue ಮಾಡಿ. To hold election.
Yes.
ಇಪ್ಪತ್ತೊಂಬತ್ತು 5/21 ಇಲೆಕ್ಷನ್ ಮಾಡೋದಕ್ಕೆ ಕ್ಯಾಲೆಂಡರ್ ಆಫ್ ಇವೆಂಟ್ಸ್ ಇಶ್ಯೂ ಆಯ್ತು. Therefore, this I am bringing to your lordship's notice to say there is no dispute, nor can anybody contend that as on that date there was no vacancy. On the other hand, they have reported it as a vacancy. It will not be available for anybody to say that there was. Once this vacancy is declared, can a vacancy be saying that on such and such a date, if there was an occupant, again it would have become vacant? TAPCMS seat ಮುಂದೆ ವೇಕೆಂಟ್ ಆಗ್ತದೆ ಅಂತ ಮತ್ತೊಂದ್ಸಲ ವೇಕೆಂಟ್ ಸೀಟಿಗೆ ವೆದರ್ ದಟ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಕ್ಯಾನ್ ಬಿ ಅಡ್ವಾನ್ಸ್ ವುಡ್ ಬಿ ದಿ ದಿಸ್ ಥಿಂಗ್. Now your lordships wanted to.
So no, I want to know
resolution
whether is it a nomination made from the taluk to the district?
How?
Is it it's
How?
nomination?
Nomination ಅಲ್ಲ.
Huh?
ತಾಲೂಕಿನಿಂದ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಸೊಸೈಟಿಗೆ ಇಲೆಕ್ಷನ್ ನಲ್ಲಿ
Election ಆಗುತ್ತೆ.
ಆಗುತ್ತೆ.
So this person is elected as a director.
Director.
Is that election as a director co-terminus with the
With the board, 5 years.
term of this person in the taluk board?
5 years. Unless I incur any disqualification in the interim.
No. Is it co-terminus with his say membership?
Primary society.
It is co-terminus.
Co-terminus ಅಂತ ಅಂದ್ರೆ ಅಲ್ಲಿ ಇಲೆಕ್ಷನ್ ಆಗಿ re-elect ಆದ್ರೆ it will not be affected. ಅಲ್ಲಿ election ಆಗದೆ ಹೋದ್ರೆ he will cease to be a director there, which will entail a consequence here also. ಈಗ ವೇಕೆಂಟ್ ಸೀಟ್ ಡಿಕ್ಲೇರ್ ಆದ ಸೀಟ್ ನಲ್ಲಿ whether there can be a further vacancy. It was a vacant seat. There is no question of any other thing happening to that. ಇದಾದ ನಂತರ in the meanwhile, before this my appeal was allowed, election to TAPCMS was held. I contested the election.
That is only in 19/5/2023.
ಹೌದು, ನಾನಂದ್ರೆ ಅದನ್ನ ಯಾಕೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಅಂದ್ರೆ as on date they cannot say that you are not a director. ನನ್ನ ಅಪೀಲ್ ಅಲೋ ಆಗೋದಕ್ಕಿಂತ ಮೊದಲೇ ಅಲ್ಲಿ ಎಲೆಕ್ಷನ್ ನಿಂತು I have again become a director.
When was that appeal allowed?
Appeal was allowed on 19/5/2023. Appeal allow ಆಗಿತ್ತು.
Where is that order?
That is annexure
Annexure
A.
Annexure A.
Annexure A. Date ending. Page 31 ನಲ್ಲಿ ಬಾಟಮ್ ಡೇಟ್ ಇದೆ.
Correct. 19/5/2023. Your disqualification was set aside.
ಹೌದು. Order was set aside. Appeal was allowed.
Then election was held there.
TAPCMS ಗೆ ಎಲೆಕ್ಷನ್ ಆಗಿದ್ದು 24/1/23. ಬಟ್ ನನ್ನ ಸೀಟಿನ
24
1/23, ಬಟ್ ನನ್ನ ಸೀಟಿನ ಎಲೆಕ್ಷನ್ there was stay because of some other controversy. Stay was vacated on 28/10. 24/2/23 I was declared as elected director. Annexure G, page 40.
Yes.
24/2/23 I was declared as elected as a director. Appeal ಆಗೋ ಡೇಟಿಗೆ I was a director of TAP CMS. ಅದು ತಾವು ರೆಸಲ್ಯೂಷನ್ kindly see the resolution. Unless I am contradicted by any records by the bank. ಬ್ಯಾಂಕಿನವರು ಸೆಕ್ಷನ್ 18(1)B ಅಲ್ಲಿ ವೇಕೆನ್ಸಿ ಆಗಿದೆ, ಅದನ್ನ ತುಂಬೋದಕ್ಕಾಗಿ ನಾಮಿನೇಷನ್ ಮಾಡ್ತೇವೆ ಅಂತ ಹೇಳಿ. ದಟ್ ವಾಸ್ ನಾಟ್ ದಿ ನೋಟ್ ಪುಟ್ ಅಪ್, ದಟ್ ವಾಸ್ ನಾಟ್ ದಿ ಅಜೆಂಡಾ. Kindly see the agenda.
Yes.
Page 40.
29E ಅಂತಾನೆ ಹೇಳ್ತಾರೆ ಅವರು.
ಹೌದು. ಬ್ಯಾಂಕಿನ ಆಡಳಿತ ಮಂಡಳಿಯಲ್ಲಿ ಖಾಲಿ ಇರುವ ಶಿವಮೊಗ್ಗ ವಿಭಾಗದ ಕೃಷಿ ಉತ್ಪನ್ನ ಮಾರಾಟ ಸಹಕಾರ ಸಂಘ ಇತರೆ ಸ್ವಯಂ ಸ್ಥಾನಕ್ಕೆ ಸಹಕಾರ ಸಂಘಗಳ ಕಾಯ್ದೆ 29E ಅನ್ವಯ ನಾಮನಿರ್ದೇಶನ ಮಾಡುವ ಮೂಲಕ ಭರ್ತಿ ಮಾಡುವ ವಿಷಯ. ಬ್ಯಾಂಕಿನ ಆಡಳಿತ ಮಂಡಳಿಯಲ್ಲಿ ತೆರವಾಗಿರುವ ಶಿವಮೊಗ್ಗ ವಿಭಾಗದ ವ್ಯಾಪ್ತಿಗೆ ಬರುವ ಕೃಷಿ ಉತ್ಪನ್ನ ಮಾರಾಟ ಹಾಗೂ ಇತರೆ ಮಾರಾಟ ಸಂಸ್ಕರಣಾ ಸಹಕಾರ ಸಂಘಗಳ ನಿರ್ದೇಶಕರ ಸ್ಥಾನಕ್ಕೆ ನಾಮ ನಿರ್ದೇಶನದ ಮೂಲಕ ಭರ್ತಿ ಮಾಡಿಕೊಳ್ಳುವ ಬಗ್ಗೆ ಮಾನ್ಯ ಅಧ್ಯಕ್ಷರು ಪ್ರಸ್ತಾಪಿಸಿದರು. ಶ್ರೀ ಸ್ವಯಂಸು ಇವರು ನೀವು ಯಾರ ಒತ್ತಾಯದ ಮೇರೆಗೆ ಸದರಿ ವಿಷಯವನ್ನು ತಂದಿದ್ದೀರಿ ಎಂದು ಕೇಳಲಾಗಿ ಅಧ್ಯಕ್ಷರು ಉತ್ತರಿಸಿದ ಈ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಇದರಲ್ಲಿ ಯಾರ ಒತ್ತಡವೂ ನನಗೆ ಇಲ್ಲ, ನನ್ನ ವಿವೇಚನೆಯಿಂದ ಆಡಳಿತ ಮಂಡಳಿಗೆ ತಂದಿದ್ದೆ. ಮುಂದುವರೆದು ಮೇ 21ರಲ್ಲಿ ಚುನಾವಣಾ ಪ್ರಾಧಿಕಾರದಿಂದ ಕೃಷಿ ಉತ್ಪನ್ನ ಮಾರಾಟ ಸಹಕಾರ ಸಂಘಗಳು ಸ್ವಯಂಸೋ ನಿರ್ದೇಶಕರ ಸ್ಥಾನಕ್ಕೆ ಚುನಾವಣಾ ಅಧಿಸೂಚನೆಯನ್ನು ಹೊರಡಿಸಿದ್ದು, ನಂತರದಲ್ಲಿ ಚುನಾವಣಾ ವೇಳಾಪಟ್ಟಿಯನ್ನು ಉಪವಿಭಾಗ ಅಧಿಕಾರಿಗಳು ರಿಟರ್ನ್ ಅಧಿಕಾರಿ ಹೊರಡಿಸಿದ್ದು, ತದನಂತರ ಚುನಾವಣಾ ಡೆಲಿಗೇಟ್ ಫಾರ್ಮ್ಗಳನ್ನು ಸಹಕಾರ ಸಂಘಗಳಿಗೆ ಕಳಿಸಿಕೊಟ್ಟಿದ್ದು, COVID-19 ಸಾಂಕ್ರಾಮಿಕ ರೋಗ ದೇಶವ್ಯಾಪ್ತಿ ಹರಡುತ್ತಿದ್ದುದರಿಂದ ಸರ್ಕಾರದ ಆದೇಶದಂತೆ ಚುನಾವಣೆ ಮಾಡಬಾರದೆಂದು ಚುನಾವಣಾ ಪ್ರಾಧಿಕಾರವು ತಾತ್ಕಾಲಿಕವಾಗಿ ತಡೆ ಹಿಡಿದಿತ್ತು. ಇತ್ತೀಚೆಗೆ COVID-19 ಸಾಂಕ್ರಾಮಿಕ ರೋಗ 2ನೇ ಅಲೆ ಕಡಿಮೆಯಾಗಿರುವುದರಿಂದ ಈ ಹಿಂದೆ ಯಾವ ಹಂತದಲ್ಲಿ ಚುನಾವಣೆಗಳು ತಡೆಯಾಗಿರುತ್ತವೆಯೋ ಅಂತಹ ಚುನಾವಣೆಗಳನ್ನು ಆ ಹಂತದಿಂದ ಮುಂದುವರಿಸಲು ಅನುಮತಿಸಿರುವುದರಿಂದ ಮತ್ತೆ ಚುನಾವಣೆ ಪ್ರಕ್ರಿಯೆ ಪ್ರಾರಂಭ ಆಗುತ್ತದೆ. ಕ್ಯಾಲೆಂಡರ್ ಆಫ್ ಇವೆಂಟ್ಸ್ ಇತ್ತು, ಅದನ್ನ ಸ್ಟೇ ಆಗಿದೆ, ಇದು ನಿಲ್ಲಿಸಿದ್ದಾರೆ, ಮತ್ತೆ ಶುರುವಾಗಬಹುದು ಸದ್ಯ. ಈ ಹಂತದಲ್ಲಿ ಕೈಂಡ್ಲಿ ಸಿ ದೀಸ್ ವರ್ಡ್ಸ್. ಈ ಹಂತದಲ್ಲಿ ಈಗಿನ ಆಡಳಿತ ಮಂಡಳಿಯು ಆಯ್ಕೆಯಾಗಿ 2.5 ವರ್ಷಗಳು ಪೂರ್ಣಗೊಂಡಿರುವುದರಿಂದ ಬ್ಯಾಂಕಿನಲ್ಲಿ 1 ವರ್ಷದಿಂದ ತೆರವಾಗಿರುವ ನಿರ್ದೇಶಕರ ಸ್ಥಾನವನ್ನು ನಾಮನಿರ್ದೇಶನ ಮಾಡಿಕೊಳ್ಳುವ ಸಂಪೂರ್ಣ ಅಧಿಕಾರ ಆಡಳಿತ ಮಂಡಳಿಗೆ ಇರುವುದರಿಂದ ಆಡಳಿತ ಮಂಡಳಿಯೇ ಕೋಆಪ್ಟ್ ಮಾಡಿಕೊಂಡರೆ ಚುನಾವಣೆ ಪ್ರಕ್ರಿಯೆ ಅವಶ್ಯವಿಲ್ಲ. ಇದಕ್ಕೆ ಯಾವ ನಿರ್ದೇಶಕರ ಒತ್ತಡ ಇಲ್ಲ, ಅಧ್ಯಕ್ಷರ ವಿವೇಚನೆಗೊಳಪಟ್ಟು ಮಂಡಿಸಿರುವುದಾಗಿ ಗಮನಕ್ಕೆ ತಂದರು. ಅವರು ತಮ್ಮ ಟರ್ಮ್ 2.5 ವರ್ಷ ಮುಗಿದ ನಂತರ ಈ ಸಬ್ಜೆಕ್ಟ್ ತಂದು TAPCMS ಗೆ ಇಲೆಕ್ಷನ್ ಮಾಡೋ ಸಾಧ್ಯತೆ ಐತಿ, ಇಲೆಕ್ಷನ್ ಅವಶ್ಯಕತೆ ಇಲ್ಲ, ನಮ್ಮ ಟರ್ಮ್ 2.5 ಆಗೈತಿ, ನಾವು ವಿ ಕ್ಯಾನ್ ಕೋಆಪ್ಟ್, ಇಲೆಕ್ಷನ್ ಈಸ್ ನಾಟ್ ನೆಸೆಸರಿ, ವಿ ಕ್ಯಾನ್ ಕೋಆಪ್ಟ್ ಅಂತ. ದಟ್ ಈಸ್ ಹೌ ದರ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಆಫ್ ದಿ ಲಾ ವಾಸ್. ಶ್ರೀ ಸುಧೀರ್ ನಿರ್ದೇಶಕರು ಮಾತನಾಡಿ 2.5 ವರ್ಷ ಮುಗಿದಿದೆ ಅಂದ ಮೇಲೆ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಸದರಿ ಪ್ರಕರಣ ಯಾವ ಹಂತದಲ್ಲಿದೆ ಅದರ ಬಗ್ಗೆ ಮಾಹಿತಿ ಕೇಳಿದರು. ಷಡಾಕ್ಷರಿ ಅವರು ಮಾತನಾಡಿ ಗೌರವ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಯಾವ ಹಂತದಲ್ಲಿ ಇದೆ ಎಂಬುದರ ಬಗ್ಗೆ ವಿವರಣೆ ಕೇಳಿದರು. ಮಾನ್ಯ ಅಧ್ಯಕ್ಷರು ಮಾತನಾಡಿ ರಾಜ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಮಂಜುನಾಥ ಗೌಡ ಇವರು ನ್ಯಾಯಾಲಯದ ಮೊರೆ ಹೋಗಿದ್ದು, ನ್ಯಾಯಾಲಯದಲ್ಲಿ ವಾದ ವಿವಾದ ಆಗಿದ್ದು, ಕಾನೂನು ತಜ್ಞರ ಜೊತೆ ಕೋಆಪ್ಟ್ ಮಾಡಿಕೊಳ್ಳುವ ವಿಷಯದ ಬಗ್ಗೆ ಚರ್ಚಿಸಲಾಗಿದ್ದು, ನಾಮನಿರ್ದೇಶನ ಮಾಡಿಕೊಳ್ಳಬಹುದು ಯಾವುದೇ ತೊಂದರೆ ಇಲ್ಲವೆಂದು ಅಭಿಪ್ರಾಯ ವ್ಯಕ್ತಪಡಿಸಿರುವುದನ್ನು ತಿಳಿಸಿದರು. ಕೇಸ್ ಪೆಂಡಿಂಗ್ ಇದೆ, ಬಟ್ ನಾಮನಿರ್ದೇಶನ ಮಾಡ್ಕೊಳ್ಳೋದಕ್ಕೆ ಏನೂ ತೊಂದರೆ ಇಲ್ಲ ಅಂತ ಕಾನೂನು ಲೀಗಲ್ ಒಪಿನಿಯನ್ ತಗೊಂಡಿದ್ದೀವಿ. ಶ್ರೀ ಷಡಕ್ಷರಿ ಉಪಾಧ್ಯಕ್ಷರು ಮಾತನಾಡಿ, ಕೋಆಪ್ ಸಂಬಂಧ ಸರ್ಕಾರದ ಅಡ್ವೊಕೇಟ್ ಜನರಲ್ ಬೆಂಗಳೂರು ಇವರಿಂದ ವಿವರಣೆ ಪಡೆಯುವಂತೆ ತಿಳಿಸಿದರು ಹಾಗೂ ಈ ವಿಷಯವನ್ನು ಮುಂದೂಡಲು ಕೋರಿದರು. ಮಾನ್ಯ ಅಧ್ಯಕ್ಷರು ಮಾತನಾಡಿ, ಉಪವಿಭಾಗದಿಂದ ಕೃಷಿ ಉತ್ಪನ್ನ ಮಾರಾಟ ಸಂಘ ಸೋ RN ಮಂಜುನಾಥ್ ಗೌಡ ಇವರು TAPCMS ಸಂಘದ ಪರವಾಗಿ ಆಯ್ಕೆಯಾಗಿದ್ದು, ಇದೀಗ TAPCMS ಅವಧಿ ಮುಕ್ತಾಯಗೊಂಡಿರುವುದರಿಂದ ಆಡಳಿತಾಧಿಕಾರಿಯೂ ಇರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಅದರ ಮೂಲಕ DCC ಬ್ಯಾಂಕಿಗೆ ಬಂದ ಮಂಜುನಾಥ್ ಗೌಡ ಇವರು TAPCMS ನಲ್ಲಿ ಸಹ ನಿರ್ದೇಶಕರಾಗಿರುವುದಿಲ್ಲ. ಕಾನೂನು ತಜ್ಞರನ್ನು ಸದರಿ ವಿಷಯದ ಬಗ್ಗೆ ಕೇಳಲಾಗಿ, ಬ್ಯಾಂಕಿನ ಆಡಳಿತ ಮಂಡಳಿಗೆ ಚುನಾವಣೆ ನಡೆದು 2.5 ವರ್ಷಗಳ ಅವಧಿ ಮುಗಿದಿರುವುದರಿಂದ ಮಂಜುನಾಥ್ ಗೌಡ ಇವರು 29C8BCD ಅನ್ವಯ ನಿರ್ದೇಶಕರ ಸ್ಥಾನವನ್ನು, ತತ್ಪರಿಣಾಮ ಕರ್ನಾಟಕ ಸಹಕಾರ ಸಂಘ 18B ರೀತಿಯ ಅವರು ಪ್ರತಿನಿಧಿಸುತ್ತಿರುವ ಶಿವಮೊಗ್ಗ ತಾಲೂಕು ವ್ಯವಸಾಯ ಉತ್ಪನ್ನ ಮಾರಾಟ ಸಹಕಾರ ಸಂಘ ಇದರಲ್ಲಿಯೂ ಸದಸ್ಯತ್ವ ಸ್ಥಾನವನ್ನು ಕಳೆದುಕೊಂಡಿರುವುದರಿಂದ ಬ್ಯಾಂಕಿನಲ್ಲಿ ತೆರವಾದ ಸ್ಥಾನವನ್ನು ಕೋಆಪ್ ಮುಖಾಂತರ ಭರ್ತಿ ಮಾಡಿಕೊಂಡು ಕಲಂ 29E ಅನ್ವಯ ಆಡಳಿತ ಮಂಡಳಿಗೆ ಪೂರ್ಣ ಅಧಿಕಾರ ಇರುತ್ತದೆ. ಆದ್ದರಿಂದ ಖಾಲಿ ಇರುವ ನಿರ್ದೇಶಕರ ಸ್ಥಾನವನ್ನು ಕೋಆಪ್ಟ್ ಮಾಡಿಕೊಳ್ಳಬಹುದಾಗಿರುತ್ತದೆ ಹಾಗೂ ಕೋಆಪ್ಟ್ ಮಾಡಿಕೊಳ್ಳುವ ಅಧಿಕಾರ ಬ್ಯಾಂಕಿನ ಆಡಳಿತ ಮಂಡಳಿಗೆ ಇರುತ್ತದೆ ಎಂದು ತಿಳಿಸಿರುವುದನ್ನು ಸಭೆಯ ಗಮನಕ್ಕೆ ತಂದರು. ಕೋಆಪ್ಟ್ ಮಾಡಿಕೊಳ್ಳಲು ತಡೆಯಾಜ್ಞೆ ಇಲ್ಲ, ಸರ್ಕಾರಿ ಆದೇಶ ಇಲ್ಲ, ಆಡಳಿತ ಮಂಡಳಿಯ ವಿವೇಚನೆಗೆ ಬಿಟ್ಟಿದ್ದಾರೆ. ಒಂದು ವೇಳೆ ಗೌರವ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಿಂದ ಆದೇಶ ಬಂದಲ್ಲಿ ಬ್ಯಾಂಕ್ ಸದರಿ ಆದೇಶವನ್ನು ಪಾಲನೆ ಮಾಡಬೇಕಾಗುತ್ತದೆ ಅಂತ ಹೇಳಿ, ಅಕಾರ್ಡಿಂಗ್ ಟು ದೆಮ್ ನಾವೀಗ ಕೋಆಪ್ಟ್ ಮಾಡ್ಕೊಂತೀವಿ. ಅಕಸ್ಮಾತ್ ಹೈಕೋರ್ಟ್ ನಿಂದ ಬೇರೆ ಏನಾದ್ರು ಆದೇಶ ಬಂದ್ರೆ ಅಥವಾ ಮಂಜುನಾಥ್ ಗೌಡರ ಅಪೀಲ್ ಅಲೋ ಆದ್ರೆ ಅದನ್ನ ಪಾಲನೆ ಮಾಡಬೇಕಾಗುತ್ತದೆ ಅಂತೇಳಿ ಹೇಳಿದ್ರು. ನಿರ್ದೇಶಕರಾದ ವೆಂಕಟೇಶ ದುಗ್ಗಪ್ಪಗೌಡ ಇವರುಗಳು ಈ ಸಂಬಂಧ ಕಾನೂನು ಸಲಹೆ ಪಡೆದು ಮುಂದಿನ ಕ್ರಮವಿಡುವಂತೆ ಅಭಿಪ್ರಾಯ ವ್ಯಕ್ತಪಡಿಸಿದರು. ಸಹಕಾರ ಸಂಘಗಳ ಉಪನಿಬಂಧಕರು ಮಾತನಾಡಿ, ಕರ್ನಾಟಕ ಸಹಕಾರ ಸಂಘಗಳ 29E ರೀತಿಯ ಕೋಆಪ್ ಮಾಡಿಕೊಳ್ಳುವುದಾದಲ್ಲಿ ಆಡಳಿತ ಮಂಡಳಿಯ ಅವಧಿ 2.5 ವರ್ಷ ಮೀರಿರಬೇಕು. ಹಾಲಿ ಆಡಳಿತ ಮಂಡಳಿಯ ಅವಧಿ 2.5 ವರ್ಷ ಪೂರ್ಣಗೊಂಡಿದೆ. ಇದಕ್ಕೆ ಕೋರ್ಟ್ನಲ್ಲಿ ಯಾವ ತರಹದ ತಡೆಯಾಜ್ಞೆ ಬಂದಿದೆಯಾ ಎಂದು ವ್ಯವಸ್ಥಾಪಕ ನಿರ್ದೇಶಕರನ್ನು ವಿಚಾರಿಸಲಾಗಿ ಯಾವುದೇ ತಡೆಯಾಜ್ಞೆ ಇರುವುದಿಲ್ಲ ಎಂದು ಸ್ಪಷ್ಟೀಕರಣ ನೀಡಲಿದ್ದಾರೆ. ಯಾವುದೇ ನಿರ್ದೇಶಕರ ಸ್ಥಾನವು ಖಾಲಿಯಾದ ತಕ್ಷಣದಲ್ಲಿ ತೆರವಾದ ನಿರ್ದೇಶಕರ ಸ್ಥಾನವನ್ನು ಚುನಾವಣೆ ಮೂಲಕ ಭರ್ತಿ ಮಾಡುವುದಕ್ಕೆ ಕ್ರಮ ಇಡಬೇಕಾಗಿತ್ತು. ಅದರಂತೆ ವ್ಯವಸ್ಥಾಪಕ ನಿರ್ದೇಶಕರು ಚುನಾವಣೆ ಆಯೋಗಕ್ಕೆ ಪತ್ರ ಬರೆದು ಚುನಾವಣೆ ಘೋಷಣೆಯಾಗಿದ್ದು, ಈ ಸಂಬಂಧ COVID-19 ಸಾಂಕ್ರಾಮಿಕ ರೋಗ ಹೆಚ್ಚಿಗೆ ಇದ್ದುದರಿಂದ ಚುನಾವಣೆ ಪ್ರಕ್ರಿಯೆ ಸ್ಥಗಿತಗೊಂಡಿತು. ಅನಂತರದಲ್ಲಿ ಚುನಾವಣೆ ಪ್ರಕ್ರಿಯೆಯಂತೆ ಚುನಾವಣಾಧಿಕಾರಿಗಳು ಚುನಾವಣೆಯನ್ನು ನಡೆಸಬೇಕಾಗಿತ್ತು. ಆದರೆ ಆಡಳಿತ ಮಂಡಳಿಯ ಅಧಿಕಾರ ಅವಧಿಯು 2.5 ವರ್ಷ ಮೀರಿರುವುದರಿಂದ ಕೋಆಪ್ಟ್ ಮೂಲಕ ಭರ್ತಿ ಮಾಡಲು ಆಡಳಿತ ಮಂಡಳಿಗೆ ಸಂಪೂರ್ಣ ಅಧಿಕಾರವಿರುವುದರಿಂದ ಬ್ಯಾಂಕಿನ ಆಡಳಿತ ಮಂಡಳಿ ಇದನ್ನು ಕೋಆಪ್ಟ್ ಮಾಡಿಕೊಳ್ಳಬಹುದು. ತೆರವಾದ ಸ್ಥಾನವನ್ನು 3 ತಿಂಗಳೊಳಗೆ ತುಂಬದೇ ಇದ್ದರೆ ಸರ್ಕಾರಕ್ಕೆ ಅಧಿಕಾರ ಇರುವುದರಿಂದ ಸರ್ಕಾರದಿಂದ ಆ ಸ್ಥಾನವನ್ನು ಭರ್ತಿ ಮಾಡಲಾಗುವುದು ಎಂದು ತಿಳಿಸಿದರು. ಆದ್ದರಿಂದ ಬ್ಯಾಂಕ್ ಮುಂದಿನ ಕ್ರಮ ಇಡಬೇಕಾಗುತ್ತದೆ ಎಂದು ಗಮನಕ್ಕೆ ತಂದರು. ಶ್ರೀ ಸ್ವಯಂಸೋ ಇವರು ಅಧ್ಯಕ್ಷರ ಸ್ಥಾನಕ್ಕೆ ಅರ್ಜಿ ಹಾಕಿದ್ದರು. ಆದರೆ ಅಂದಿನ ಮಾಜಿ ಅಧ್ಯಕ್ಷರಾದವರು, ನಮ್ಮ ಬ್ಯಾಂಕು ಯಾವತ್ತಿಗೂ ಪಕ್ಷ ರಾಜಕೀಯ ನಡೆಸಿಲ್ಲ, ಇದು ಸಹಕಾರಿ ಕ್ಷೇತ್ರವಾಗಿರುವಂತ ಇಲ್ಲಿ ಪಕ್ಷಾತೀತ ಆಡಳಿತ ನಡೆಸಿಕೊಂಡು ಹೋಗಬೇಕಾಗಿರಬಹುದು, ನಿಮ್ಮೆಲ್ಲರ ಜವಾಬ್ದಾರಿ ಎಂಬ ಸೂಚಿಸಿರುವ ಮೇರೆಗೆ ಆಡಳಿತ ಮಂಡಳಿ ನಿರ್ದೇಶಕರ ಸ್ಥಾನಕ್ಕೆ ಒಟ್ಟು 14 ಮತಗಳು ಸಂಪೂರ್ಣ ಅಂದ್ರೆ ಅವರವರೊಳಗಿನ ವಿಷಯಗಳನ್ನು ಚರ್ಚೆ ಮಾಡ್ಕೊಂತಾರೆ. ವಿಷಯ ಸಂಖ್ಯೆ 30 ಮುಂದೂಡುವಂತೆ ನಿರ್ಣಯಿಸಲು ತಿಳಿಸಿರುತ್ತಾರೆ. ಮಾನ್ಯ ಸಹಕಾರ ಸಂಘಗಳ ಉಪನಿಬಂಧಕರು ಮೇಲೆ ತಿಳಿಸಿಕೊಳ್ಳುವಂತೆ ಕೋಆಪ್ಟ್ ಮಾಡಲೇಬೇಕು. ಇದನ್ನು ಖಾಲಿ ಬಿಡಲು ಸಹಕಾರಿ ಕಾಯ್ದೆಯನ್ನು ಬರುವುದಿಲ್ಲವೆಂದರು. ಈ ಸಂದರ್ಭದಲ್ಲಿ ದಿನೇಶ್ ರವರು, ಹಾಗಾದರೆ ಮಾನ್ಯ ವಿಧಾನ ಪರಿಷತ್ ಸದಸ್ಯರಾದ ಪ್ರಸನ್ನ ಕುಮಾರ್ ಅವರು ಭದ್ರಾವತಿ TAPCMS ನಲ್ಲಿ ನಿರ್ದೇಶಕರಾದ ಅತ್ತಿಗುಂದ ಶ್ರೀನಿವಾಸ್ ಅವರನ್ನು ಕೋಆಪ್ಟ್ ಮಾಡಿಕೊಳ್ಳಲು ವಿನಂತಿಸಿರುತ್ತಾರೆ ಹಾಗೂ ಹಾಪ್ಕಾಮ್ಸ್ ನಿರ್ದೇಶಕರಾದ ವಿಜಯ್ ಕುಮಾರ್ ರವರು ತಮ್ಮನ್ನು ಕೋಆಪ್ಟ್ ಮಾಡಿಕೊಳ್ಳಲು ಕೇಳಿಕೊಂಡಿರುತ್ತಾರೆ. ಹಾಗಾಗಿ ಈ ಇಬ್ಬರ ಹೆಸರನ್ನು ತಾವು ಪರಿಗಣಿಸಲು ವಿನಂತಿಸುವುದಾಗಿ ತಿಳಿಸಿದರು. ವಿಷಯದ ಬಗ್ಗೆ ನಿರ್ದೇಶಕರಾದ ಯೋಗೇಶ್ ಅವರು ಮಾತಾಡಿ, ಕುಮಾರಿ ಧರ್ಮಗೌಡ ಅಥವಾ ಎಸ್
that is regarding who they wanted to select. Yes.
ಕೊನೆಗೆ ಇದೆಲ್ಲ ಆದ ನಂತರ ಲಾಸ್ಟ್ ಸುದೀರ್ಘ ಚರ್ಚೆಯ ನಂತರ ಉಪಾಧ್ಯಕ್ಷರು ಈ ವಿಷಯದ ಬಗ್ಗೆ ತಮ್ಮ ಅಸಮ್ಮತಿ ಇರುವುದಾಗಿ ತಿಳಿಸಿದರು. ಅಂತಿಮವಾಗಿ ಬಿ.ಕೆ. ಗುರುರಾಜ್ ಅಧ್ಯಕ್ಷರು ಶಿವಮೊಗ್ಗ ಜಿಲ್ಲಾ ಕೈಗಾರಿಕೆ ಸ್ವಯಂಸು ತೆರವಾದ ಉಪವಿಭಾಗ ವ್ಯಾಪ್ತಿಗೆ ಬರುವ ಕೃಷಿ ಉತ್ಪನ್ನ ಮಾರಾಟ ಸಹಕಾರ ಸಂಘ ಸ್ವಯಂಸು ಕ್ಷೇತ್ರದ ನಿರ್ದೇಶಕರ ಸ್ಥಾನಕ್ಕೆ ಸಂಘಗಳ ಕಾಯ್ದೆ 21E ಅನ್ವಯ ನಾಮನಿರ್ದೇಶನ ಮೂಲಕ ನಿರ್ದೇಶಕರನ್ನಾಗಿ ಭರ್ತಿ ಮಾಡಿಕೊಳ್ಳತಕ್ಕದ್ದೆಂದು ಬಹುಮತದಿಂದ ತೀರ್ಮಾನಿಸಲಾಯಿತು. According to them, 2.5 years is over as on that date. Therefore, they can co-opt. It is under that impression they have co-opted. Actually, this co-option would have gone as illegal because 2.5 years is referable to the date of vacancy and not the date when the term meeting is called. Therefore, but by that time, fortunately or unfortunately, that amendment came. 29E second provision came. ಅಲ್ಲಿ ಅಕಸ್ಮಾತ್ ಎಲೆಕ್ಷನ್ ಅಥಾರಿಟಿ ಅವರು ಎಲೆಕ್ಷನ್ ಮಾಡಿರದೆ ಹೋದರೆ till election is held. Second provision.
Yes.
Provided further that the board may fill up casual vacancy of the board by nomination out of the same class of members in respect of which casual vacancy has arisen till the election is held for such vacancy. ಈ ವೇಕೆನ್ಸಿಗೆ ಎಲೆಕ್ಷನ್ ಅಥಾರಿಟಿ ಅವರು ಎಲೆಕ್ಷನ್ ಮಾಡೋಲ್ಲಿವರೆಗೆ they can have a person. ಈ ಅಮೆಂಡ್ಮೆಂಟ್ ಅವರು ರೆಫರ್ ಮಾಡೋದಿಲ್ಲ. But this amendment saved them. Otherwise, it would have been challenged on that day, pointing out they cannot fill up this vacancy by co-option. It has to be by election, would have been the case. But this amendment came just prior to this co-option. Therefore, it can be said to be legal under that second provision till election authority holds election. Fortunately for me, before election authority held election, my appeal is allowed. Therefore, how I am putting my case is this now. Once a vacancy arises in respect of a constituency, I represented the constituency of TAPCMS in the election to the DCC Bank. My seat became vacant on 14/10/2020 because of the order of disqualification. I was removed from the board and disqualified from contesting election for 5 years. The order that was passed was removing from the existing board and this. Therefore, on that day, seat became vacant. Whether TAPCMS term would have been completed, etc., all those things, in respect of a vacant seat, will not arise. This vacancy was within their knowledge. They reported it to election authority. Therefore, question of whether I ceased to be a member because TAPCMS election was not held on that day, etc., fails into insignificance that would not be of any consequence at all. In that circumstance, whether they could have co-opted. But for this amendment, they could not have co-opted because it was to be an election. It had arisen prior to 2.5 years. But they co-opted. That is can be justified as an ad hoc arrangement. Therefore, now that my appeal is up, now that I am a director in TAPCMS also, reinstate me. If you say, in spite of the appellate order, there is something else which disqualifies you, that you can do only after reinstating. First reinstate me. If there is anything else against me, do it after. Follow the order. I was removed by an order. That order is set aside. Therefore, the position as it obtained on that, this could have been defeated in two manners. One, if by any chance election authority had held the election, then I could not have sought for reinstatement because statutorily a third party holds the election and fills it. Second is, by the time my appeal was allowed, if 5 years term of DCC Bank was over, then also I could not have sought for reinstatement. Now they have fixed a meeting. It was the meeting was to be held on 9/6/2023. It was postponed for some administrative reasons. Now that meeting is to be held on, the actual meeting is to be held on 17/6/2023.
For what?
The DCC Bank meeting. But not only subjects or importance of subject, I as a director am entitled to a notice of the meeting. 9/6 ಗೆ ನಾನು ಕೊಡೋದಿಲ್ಲ ಅಂತ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಇಶ್ಯೂ ಮಾಡಿ. ಅಂದ್ರೆ ನಿಮಗೆ ನೋಟಿಸ್ ಕೊಡೋದಿಲ್ಲ, you are not entitled. That meeting, for several administrative reasons, it was adjourned, and now they have called it to 19/6/23. 17/6/23. Therefore, my respectful submission is, my lord, as far as I am concerned, I have argued the matter in full for final disposal also. But in case they want time or anything of this sort, your lordship may kindly grant an interim order directing them to allow me to participate as a director in the meeting of 17/6.
Yes. You are arguing on behalf of whom? The society and the society is to answer this, not you. ನಿಮಗೂ ಆಮೇಲೆ ಬರೋಣ, later, not now, not at this stage. Yes.
Falls under section 18B. Section 29B, there are the provisos. Section 20.
Yes.
29B was guidance. But before that, you just plots keep 2-3 dates which are very rare for the purpose of plots.
Yes.
Plots kindly see note 6/5/2019.
Yes.
Is the date on which the board was constituted.
Yes.
That is not the federal system. Okay. But then 17/5 plots may not be relevant because plots the petitioner was elected as the president of the bank. But section 29E plots clearly says that the board, it is not the individual election of amongst the directors of the board. But then 14/7/2020 is the first disqualification. That may not be relevant for the present because the matter was remanded back and thereafter.
So at the time of disqualification, you were the president of the board.
Was the president of the board. Then 14/10/2020 is the date on which the disqualification on came.
Yes.
This is one set of facts. But the 24/5/2016, but the board in the primary society plots constituted.
Yes.
Their plots, he was the not the director. That is 24/5/2016.
Yes.
Of the PAPC. The term of the board plots came to an end on 23/5/2021.
Yes.
23/5/2021. Then plots on 24/5/2021, the administrator was appointed.
Then Lords, the repetition filed by the petitioner. Lords, there was no intermodal flow. The repetition was rejected on 17/11/2021. 17/11/2021, Lord, the petition was rejected, by which Lords, the disqualification of Lords has been settled. Then Lords, the writ appeal was filed. Even writ appeal was also dismissed on 9/2/2023. Yes, the dismissal order, the repetition. The writ appeal is filed, that is 1396/2021. Even that is also dismissed on 9/2/2023. There was no interview. Then Lords, 11/2021 is the date on which Lords the co-option takes place. Petitioner Lords got elected on 24/2/2023 in TAPC. Yes. That is in the primary society. Lords, that means Lords, from 24/5/2021 till 24/2/2023. Lords, he was not elected. That is after expiry of the 5 years of Lords, the capacity primary society.
Why election was not conducted there? Administrator was appointed.
Administrator was appointed.
Huh?
Yes, please.
COVID.
Administrator was appointed.
Election was announced, election was almost to the extent of filing nomination, it had come. But by that time, that second.
You're talking about the TAP. ಅದಕ್ಕೂ ಅಷ್ಟೇ.
ಅದೇ TAPC ಗೆ election ಇದಾಗಿದೆ. ಅದು
the date on which administrator was appointed.
No, you have pointed out during your argument that for filling up this post.
ಅದಕ್ಕೂ election ಕರೆದಿದ್ರು.
ಅದರದ್ದು ಅದೇ same.
Same reason.
Yes.
Sir, he was elected on 24/2/2020. But sir, even before the term to come to an end in the primary society, the petitioner was disqualified on 14/10/2020. But till 23/5/2021, but he was not a member of even the primary society. Then Lords, from then, that is from Lords 24/5/2021, that is for the next term, Lords, election could not be held for 2 years. Lords, even he was not elected. My submission to Lords is that in view of these dates, Lords, one is that 29E would apply, and as well as Lords section 18B, Lords section 29E may be. Filling up of casual vacancy in the office of the board. Any vacancy in the office of the board, public authority society, either of death, resignation, removal, or other, the parliamentary norms, other shall be filled in such manner as may be stipulated in the provided operating election authority shall conduct the election without any vacancy in the office of director of the board if the remaining term of office of the board is more than half of its original term. Lords, this is a proviso, Lords, which enables the authorities, Lords, if the term of the board, Lords, is more than half of its term, then Lords, the second proviso. Provided further that board may fill up annual vacancy of the board by nomination out of the same class of people, in respect of which casual vacancy has arisen, till the election is held for such vacancy. But this is proviso subsequently inserted, that is by virtue of Amendment Act 36 of 2021, with effect from 7/10/2021. But this second proviso has to be read along with the first proviso. But this is once again, if the term of the board is more than half of its term. Now,
kindly let's consider there is a sudden change in the third proviso or fourth proviso. But the third proviso says, provided further that the board may fill up the casual vacancy on the board by nomination out of the same class in respect of the casual vacancy. If the remaining term of office of the board is less than half of its original term. Here, lords, a situation which is contemplated, it is less than half of its term. The first proviso and second proviso, lords, one is that election has to be held. If the election is not held, then lords, once again proviso which says that till such term or till such time the election is held, by nomination it can be. Lords, here this is after the remaining term of the board is less than 1.5 years. Then it says it can be by nomination.
Yes, sir.
By nomination. Then was the fourth proviso provided also that if the board fails to fill up such casual vacancy within 3 months of the date of appointment, the registrar shall fill up. If the third proviso is not acted upon by the board of lords or the federal society, then lords, the authority would. This is the scheme of section 90. But here is a case where the disqualification. But one is in the member lords in the post of a director in the federal society. Lords has taken place on 14 May 2020. Then lords, there was no interim order. It could have been filled up lords by way of election, though lords the election was sought to be held. It could not happen for the reasons beyond lords the control of the ban or lords the authority. Lords now, as on the date lords, when the vacancy was required to be filled, lords, it was below 2.5 years. Then lords, the third proviso would come to.
See, going by the judgment of the division bench.
Yes.
It's clear that the time starts running on the date when the vacancy arises, not when you are seeking to fill it up.
I'm not saying lords when I have to fill up. Lords, that shall be the date. Lords, it only says lords that the remaining term is less than.
Correct. Remaining term antandre.
Term of the board.
Correct. Huh?
Term of the board.
Correct. But it has to be calculated from the date when the vacancy arises. That is the judgment of the division bench. Now you can't argue contrary to the judgment of the division bench. Yes.
But I am only what's that? That is scheme of the act. It says that 2.5 years is lesser than the nomination take place. We have got. That has taken place on 16/11/2021. Now lords, kindly come to section 18B. These are two lords grounds on which lords is not eligible to be once again hold the post of director in the bank. Section 18B. The director of a secondary cooperative society.
Yes.
The position of directorship. The director of a probably that good thoughts containing the correct.
ಅಲ್ಲ ಇದು ಅಮೆಂಡ್ಮೆಂಟ್ ಇದು ಇಟ್ಟಿದ್ದಾರೆ ಇಲ್ಲಿ. They have kept the amendment copy.
Continues lords.
ಕೆಳಗಡೆ ಅಂತ
It says a director of a secondary cooperative.
Yes. Let us see. Please read.
A director of a secondary cooperative society or a federal society or a mixed society who is a representative in another cooperative society shall cease to be a director of such cooperative society. Or if that is one, he ceases to be a director of the primary or secondary cooperative society which he represents. Then words semicolon. Or the cooperative society which nominated him as a representative withdraws his nomination. Then words the third one. The board of the cooperative society of which he is a member has been removed under section 30 or a special officer appointed under section 31. And the cooperative society, cooperative society of which he is the representative has been created. These are the four contingencies under which if lords, if any person lords loses his membership in the primary society or in the secondary society, lords he loses lords the directorship even in the society where lords he represents.
Loses directorship
In the
how?
federal society.
How?
But that is not the one.
Yes.
Contingency number one.
Yes, please read.
He seems to be a director of the primary or secondary society, cooperative society, which he represents. But when he seems to be a director, then lords.
ಅಲ್ಲ ಮುಂದೆ ವರ್ಡ್ಸ್ ಇದೆಯಾ ಅದರಲ್ಲಿ? Here it says
In case.
yes.
ತಪ್ಪಿದೆ ಅಂದ್ರೆ ನಾನು.
ಇದೆ ನನ್ನ ಹತ್ರ ಇದೆ.
That's what you are actually reading the words. That is the continuation of the first contingency. But it is not so. That is why I am referring to. But there is some confusion regarding this. Otherwise, not the launch no meaning at all. The launch reads like this. This is to be a director of the primary or secondary cooperative society which he represents. That is one clause. Then next is or in case of amalgamation, reorganization, within a cooperative society.
ಈ ವರ್ಡ್ಸ್ ತೆಗೆದಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಅದು ಅದೇ particular phrase in 2016 this was inserted. This is a separate contingency. One is it is to be a director. Second is in case where there is amalgamation, reorganization, and division.
How are you reading all this?
Just pass on because there that your certificate I had done this exercise. I was also in the confusion when I was what is this actually means? Actually said two contingencies. First contingency is where he seems to be a director. Second contingency is wherever there is an amalgamation or reorganization, he will not cease to be a director. He will continue to be a director, but he will cease only if the reorganized or the amalgamated society says no, we don't want him to continue as a director. That is the second contingency. The third contingency, fourth contingency. This part of this. That I think not in the words in the I know. When I was referring to this particular provision, even I got confused. Because at one stage it said
yes. If you read it continuously, it gives a different meaning.
It doesn't give any. It just can have check this when I have how it should be. That is amendment brought by Act 35 of 2014, 6/9/2014.
Yes.
A director of a secondary cooperative society or federal society or a mixed society who is a representative of another cooperative society. Another cooperative society means primary, secondary, or federal society.
Yes.
Shall cease to be a director of such cooperative society, or if he ceases to be a director of the primary or secondary cooperative society, which he represents. This is one thing. Or the cooperative society which nominated him as a representative because his nomination.
Or in case of amalgamation or reorganization or division of cooperative societies, he may continue to represent such society until its amalgamated, reorganized or divided society withdraws his representation by resolution.
The second thing, this is the second thing.
Yes.
Ultimately, lords, the primary society term lords has come to an end on 23/5/2021. That is lords prior to the co-op. That is, these dates are relevant for that 23/5/2021 is the date on which lord the term of the primary society has come to.
Yes.
Co-option lords is on 16/11. That is much after. Lords, another lords fact, admittedly, lords, there is no fresh resolution by which lords he has been once again lords allowed to represent lords in the federal society. These are lords the facts. Now lords, how this section 18B lords has to be considered. Lords have been the subject matter of lords 1. Repetition and appeal. Where lords have given the validity of section 18B lords was under challenge, including the constitutional power. But please let me go. That was where both of us was senior counsel and user appeared. And it attained not generic also. Verification of consent. But the very broad attention that was advanced is that since I am elected in the federal society by virtue of election, I continue to vote in term for a period of 5 years, notwithstanding whether I lose membership in the primary society or otherwise. That was the argument. There has been benefit and the observed at parameter 86, 87, and 88. But where this not will go to lots, clearly observed. Such an interpretation cannot be. Para 86. But this was a case where lords, what had happened that in the primary society there were totally lords 12 members, and out of which lords 9 members were there. On account of the quorum, the lords, the special officer was appointed.
The amendment, when did it come into this provisions? 2021?
2021.
5th of October 2021. Yes, it was gazetted 7/10/2021. This order was passed when? Resolution was passed when?
That is 16.
After this amendment. After this amendment. So they had to take note of all this provision. Going by the plain reading of this provision, the third or fourth proviso, 29E, says if you don't co-opt within a period of 3 months, then the society will lose the right. The registrar should have nominated. Your nomination has taken place after 3 months.
Sir, it is equal. In 2020 is the disqualification.
Yes.
But the petition was pending. Initially, there was an interport. But so far as this order is concerned, there was no interport asset.
Correct.
Ultimately,
yes.
We appointed notes on 16/11.
Correct.
Notes 16/11.
16/11 to more than after a year.
16/11/2021.
Yes. So going by the plain reading of the provision, the society has lost the right to co-opt.
Yes. That no one challenged.
No, it's a question of operation of law.
Operation of law.
Operation of law. Operation of the provision by law.
Yes.
Once the society loses the right, how could it appoint or co-opt? Having noticed the provisions,
Yes.
having noticed the amended provision, that nomination shall be done only till fresh elections are held. Therefore, going by the word of the provision, you should have simply co-opted and nominated only till elections are held. Then you should have reported to the registrar. Now that the term of the TAPCMS has come to an end, then the other provision will come into operation. Your 18B will come to operation only subsequently.
Not subsequent. But forthwith, that is because on 23/5/2021.
Huh?
23/5/2021, prior to the co-option.
Therefore, having lost the right to co-opt within the period of 3 months, you should have taken the permission of the registrar. You could not have simply asked for legal advice from someone and gone on like this. You should have asked the registrar what to do. This is the situation now. Now that though the period of 3 months has elapsed, we were not able to conduct election. I mean, do the co-option or nominate someone to that post. You should have done that.
The reason for not holding election.
Not holding election is different. Not holding election is a different concept.
There was a
Your power to nominate co-op within a period of 3 months had lapsed. Isn't it?
going by the amended provisions.
Yes. ಅದು ಮುಂಚೆಯಿಂದನೂ ಇತ್ತು. ಅದೇನು ಹೊಸದಾಗಿ ಬಂದಿರೋದಲ್ಲ ಅದು. That period of 3 months, that proviso was already there. ಅದೇನು ಹೊಸದಾಗಿ ಬಂದಿರೋದಲ್ಲ ಅದು.
Is where it was this nature. But no one had questioned, not including the petitioner, when not the interview was pending.
How could he question that one?
Question lots, that is when lots. He has also questioned it. Not he placed it before lots the division bench by producing lots the additional documents, including lots this co-option. Not there was no interim order asset. Even the interview was also dismissed. Not he did not take it further. Not I only request my lords to consider. Not far from the perspective that in a case where this person not who has focused standing question cannot be. It is not a public interest litigation lots where we can come and challenge lots all the orders. Not that once we to say that lots these are all in violation of certain provisions of law. That is not sufficient. Ultimately, lots when that is questioned and when that order is set aside. But though it is an illegal order, lots of questions are there. It is set aside by a competent court of law. It is allowed. But here is a case when lots that order lots was not set aside or it was not questioned at all. Now lots in the petition, kindly see lots the prayer. This is by way of alternate prayer lots he is seeking. Not what cannot be direct lots done directly. It's not be done indirectly not by challenging this provision that too after 2 years. But nothing prevented him from challenging all lots to get an order to say that since there is a disqualification order he is operating against me, I may be permitted to challenge it. That shall not come in my way to challenge it on a subsequent date or later date. That could have been. That was not done at all. But kindly see the prayer.
No.
Page 22. Page 22.
How could he make that prayer? If such a prayer was made,
Now
it was definitely to be rejected only.
now the Lord now by
How could he expect him to raise a challenge like that at that juncture?
that is when
ಆಗೋದಿಲ್ಲ.
that is when by submission is done. By the Lord's very operation of law. But under section 18, once Lord's the term has come to an end in the private system, then Lord's he uses his directorship. Consequently, he uses the directorship law in the federal society where Lord's he was represented. That is by operation.
Sir,
Now
at that point of time, he was not a director. Where is the question of his losing directorship? He was not a director at that point of time.
I only say that there was a disqualification order.
How could you read in that provision when he was not a director. Reading the provision of section 18 would come into picture only if he is a director. And you could say, yes, now that the term has come to an end, he has lost his directorship and therefore will have to proceed further. If you have to invoke the provisions of section 18, that is permissible only if he was a director. So these two provisions are totally different.
I am not on that.
Section 29 governs the procedure for co-option or for conducting election when a disqualification is incurred by a director.
As on the date when we co-opted, the fifth respondent.
Yes, yes.
I am not on the issue that he should be a director, then only he ceases to be a director.
That is the contention of the other side.
My submission is that, so far as 18B is concerned, now though there is an order which is passed by which the disqualification is set aside, but he is no longer not a director of the primary society continuously. There is a break that is from 2025, 2021 to 2023. But that is why once again there has to be a resolution passed and it shall be nominated. But since there is a break, section 18B would come in. Then cessation of membership can be on two accounts. One is that once he ceases to be a director in this one, then he can he loses the directorship. But here is a case where the term has come to an end. Thereafter, he was not elected for a period of 2 years. Now, by virtue of disqualification order being set aside, he wants to continue for the remaining term. That is impermissible, as held by the dishonorable.
Sir, cause of action arose for him only after the order of disqualification was set aside.
Yes, as on that day, but whether he continued to be a director of the primary society.
Atara ನೀವು ಕೇಳಕ್ ಬರೋದಿಲ್ಲ.
That is the requirement.
You can't put something which is not provided in the provisions. It doesn't say a previous term ಅಲ್ಲಿ ಆಗಿದ್ರ ಇಲ್ವಾ ಅದೆಲ್ಲ ಹೆಂಗ್ ಬರುತ್ತೆ? So his contention is, I was disqualified at a particular date, vacancy arose, they should have filled up in accordance with law. If they had filled up in accordance with law, it would continue only till election was held. Adaglila. So therefore, when the order of disqualification passed against me was set aside, I am again a director of the board. And going by the provisions contained in section 29E, I can ask for reinstatement only in terms of the provisions contained in section 29E. There is no question of invoking the provisions contained in section 18. That is the submission.
My answer is that if you are wrongly there is an order of co-option.
ನಿಮ್ಮ ರೆಸಲ್ಯೂಷನ್ ಅಲ್ಲೂ ಕೂಡ ಯು ಟಾಕ್ ಅಬೌಟ್ 29E ಫಿಲ್ಲಿಂಗ್ ಅಪ್ ದಿ ಅದು ಡಿಸ್ಕಷನ್ ಅಲ್ಲಿ ಬಂದಿರೋದು. ನೀವು ಡಿಸ್ಕಷನ್ ಮಾಡುವಾಗ ಅದೆಲ್ಲ ಬಂದಿದೆ. See, you can't escape the fact that the initial proposal was given for filling up of the vacancy that was created on the basis of the disqualification of this person. That is why you also wrote to the election commission to hold the elections. Isn't it?
Oblivious to lots of the certain operation of he ceases to be a director in a primary society. But that cannot be ignored. But here is a case where he loses his directorship. But that is for a period of 2 years. Though not, it is after the co-option order is passed. But But ultimately, he was not a member of Lords, even the primary society, so that Lords he can represent in the federal society. But here is a case where Lords, even in the federal society, he cannot continue because Lords, there is a break in Lords, the term of 2 years of the directorship in the primary society. That is one part. Another point, Lords, is that right here only, Lords, there is an order. Lords, now, not having questioned Lords, the order of option. Lords, early. Lords, after the 2 years, Lords, or 3 years, Lords, is it open to them? Lords, to challenge it now?
Open for him to challenge that one at that point of time.
But
How,
that is why
where does he get the locus standi to question it?
he did not
He
have
is
a
actually a disqualified person.
I agree. Even after that, Lords, even after that also. The point is that 18B Lord would still come into picture. Not because there is a break in Lords the primary. That issue, Lords, kindly consider Lords the decision of the division bench. The very issue, Lords, was raised. IAPC. Where there was an argument about that even it doesn't apply to the society of cooperative credit structure. So there was also considered. However, there is only 8, 87, 88. So that's that. Each one had been elected as a director to represent one particular constituency, a category of member, and he therefore had a right to represent the said constituency for the prescribed term of 5 years. It was stated that even the term of impeachment had something like that. But if the term of 4 of the correspondence society in the normal course, that would still not affect the impeachment tenure as a director of the 6th respondent bank. It was also alleged that if the term of impeachment is forcefully brought to a relation, there would be a vacancy created in court which would not be filled up, and this would utilize the category A. It is to be stated here that to be eligible to contest for the post of director of the 6th respondent, as per the second proviso to PPA of the cases, a resolution approving the impeachment contest is necessary, and if there is no such resolution, the nomination papers of the delegate of the primary society will not be accepted. It is not to be lost. Second of that, a director of a primary society, such as petitioner, is essentially representing the primary society in the federal or secondary society, and if he does not have the approval of the parent society, he cannot have obviously continue on board of the federal society. This position is made explicitly clear by the section 18B of the Act. Thus, the argument that the petitioner on being elected to the board was essentially representing a different constituency and they had an independent right to continue as a member, even on the dissolution of the parent board or the withdrawal of his nomination, is absolutely. But once he loses the membership Lords in the primary society, because Lords, this is like ground floor and the first floor. Lords, he is in the first floor, Lords, provided Lords, he has the pillars in the ground floor. Otherwise, Lords, the second floor cannot stand up. That's what Lords this one has observed. But now, 1960 Lords. Yes. Considering section 18B. It is not in the line of the order passed by the division. They read not very short.
Yes.
Dated 27/10/2021, followed by another order bargaining. By appointing fiscal officer, preventing ultimately, by operation of the province contained in clause 3 of section 18 of Act, it was directed that the commissioner ceases to be a director of the cooperative society, although they are responsible. The order itself is in violation of the contained in matter of J. What is not written by such. Whereas you got to think that J was under challenge in the division bench order. Is the contention of the learned council of the petitioner that the said provision in the constitution clearly provides that the term of the elected member of the board and its office bearers shall be 5 years from the date of election, and the term of office bearers shall be coterminous with the term of the board, and according to the represented council, contained in section 18B of the Act, falls within the field of the constitution. Then, unless the said provision is challenged in manner and the said provision is on the proposition that if words in the statute. Page 77, para 77, 78. Yes.
No, but for what proposition are you reading this judgment?
The proposition is that section 29E and section 18B are very clear. That to say that he uses words is a direct shade. In a case where the term has come in, or words by resignation, or words by disqualification, or otherwise when he ceases to be a direct. Here is a case where upon the completion of the term of before in the federation, he uses to be a or he ceases to be a director, and thereafter, so as continuing words in the federal society as a director does not arise. If the provisions of section 18B was considered in its textual context, it does not foresee any other situation beyond what is contemplated. And now one 11 pages 737. This is the proposition that what cannot be done there. Now we will what be done there. What it means
Yes.
My respectful submission was that. Section 29B and as well as notes 18B. By operation of law courts, he cannot be allowed to continue as a director of the. Another submission is that the option is that order notes has not been set aside. Though it is an illegal order notes, assuming as notes alleged by, but according to me, not till notes that order is set aside. The presumption notes is that it is a valid order. But 6 months there is no challenge, and that order continues to be made. Now it is not available to the petitioner notes to challenge that order because notes there is already a co-option order. Even notes in the meanwhile, he loses his directorship notes in the primary society. Now notes he doesn't have a local standard notes, notwithstanding the order notes of the disqualification of the set aside or restored notes by the consent law. He doesn't have a local standard.
Yes, Mr. Ravi Shankar.
The society with which we are dealing with, the secondary society is a district level society. The district level society's members are the primary society. Individuals have no role to play. The person who has presently come before the court, maybe I will look at the past. He has come with his individual capacity. If he wants to represent any society as a member, but certainly a member of a cooperative society will still have the right to invoke the right to jurisdiction at capacity. The person who has approached the court in his individual capacity. If he is a director of the member society or a primary society, he has a leverage to do so, provided he is so nominated to represent himself as representing the primary member society. If he says so, then he will get a right to come before the Zonal court and say that I have a local standing command. First and foremost question is whether he has said anything in the repetition, not a whisper as to how he gets the local standing, warrant on behalf of the member society. We cannot make anything. The second part of it is this, addressing what we reference here. Once election takes place to the secondary society, how the election takes place? Nomination is made by the primary member societies to participate or for the purpose of voting. The nomination is only for the purpose of voting as well as participation. Once such nomination is made, such nominated member as representing the primary society becomes eligible for the purpose of either contesting or to vote in the concerned election of the secondary society. If he participates in the election and gets elected as a director, the next contingency is what if he ceases to be a member of the original board which had nominated him to participate or to contest in the elections. Because that is captured in terms of ATP, there should be no confusion where it's set.
Yes.
Another contingency is that after he gets elected under for the secondary society, if he gets disqualified, then what happens? That is the contingency which is occurring in the present. In either of the circumstances, vacancy gets created, but in so far as 29C is concerned, it is a vacancy created on account of a disqualification. In the event of 18B, it would be a vacancy which would be created on account of he needing to be a director of the member society.
Yes.
But whether the vacancy gets created under 29C or under 18B, the procedure for the purposes of filling up that vacancy is only under 29E. If your lordship were to see 29E, it would spell out the contingencies and say or otherwise. Any contingency, because there is no other provision in law. Any other provision in law would not be available. Only contingency is that when a vacancy arises, that is how section 29E has been understood. Whenever any vacancy arises, the vacancy is required to be filled up in terms of 29E. Now, the fact situation presented in the present scenario is, assuming that I will have a license, this wanted to how the courts have understood this concept.
I have a license but without money. If my license is cancelled for any reason, I challenge the cancellation of the license. The period for which the license is granted to expire in any time. The court finds that the reason some stigma is cast upon him and that stigma should not have been cast upon him. So therefore, we direct that the sentence of the license is not valid. Extend the period.
Ingala, see, we'll put it in a different way. Suppose you are elected from the TA, MP or whatever.
Yes.
A few months, 5-6 months after your nomination, the term of the board of the TA PCMS comes to an end.
Yes.
By operation of section 18, you will lose.
This should be a director of the secondary society.
So you are right when you are submitted that the provisions contained in section 29 also contemplates the situation. So therefore, co-option has to be made, elections have to be held.
That also, I come to that point.
No. Please understand. The right of the TA MPC to send its person as its nominee.
It is still there.
So,
It is still there. I have promised also.
therefore, you can't say now that the term of that TAMPC has come to an end.
That is also covered in this section 21 of the act. I look at section 21 before I do.
No, please understand. It is an admitted fact that the vacancy was, when the vacancy was created, there was more than 2.5 years as is required under the provisions. The TAMPC had a right to send one of its persons as its nominee. Now, there is no representation from that TAMPC.
That's the reason. I will address even these two.
Yes.
I take it as a question from your answer.
Yes.
I address both the issues. Now, the post having fallen vacant, there is no difficulty.
Yes.
Now, we will ignore what section 18 makes in because 18B contingency has occurred, it's an admitted fact. But once the board changes, what is the procedure contemplated? Because that contingency has to happen because who should come and complain? The person who can complain is the society itself. What is the society? Society is either the general body of executive committee.
No.
I have looked at section 21.
No question of complaining. What does the statute, what provisions are made? We want to know about that one.
21.
Yes. Yes.
Remember, every representative, every delegate and every nominee shall exercise his vote in person and not by proxy at a general meeting or an election of the members of the board of the cooperative society. Notwithstanding anything contained in subsection 1, the board of the cooperative society, which is a member of another cooperative society, may appoint one of the members of the board to vote on its behalf in the affairs of that society. Provided that where a new board has been elected to a cooperative society, such newly elected board shall send a delegate or nominee to any other cooperative society where it is a member. That's why I'm looking at this. The first submission which I made, he says that the newly elected board has nominated him as a member, then he gets a notice. Because he is not a member. He cannot be delegated to the status of being a member because he can become a nominee of a member society, which he is not as of today. The scheme of the act itself very clearly lays down that the moment the term expires under 18B, the term is over, then it does not mean he will cease to be the director. But there are two contingencies which I am submitting. It is not that a member society is required to send only a nominee in the election and his duty ends there. No. In every general body which should be convened in every year, they are required to participate. So in every general body, whether my nominee is elected or not elected, I will be having my nominee to participate in all the proceedings of the secondary society. That is how the scheme of the act. But once the term of the primary member society ceases, then the director who might have been elected to the secondary society also ceases to exist. Then what should be done? The next contingency is twofold. Number one, first, this primary member society has to nominate that here is my nominee to the society. Secondly, the other contingency so far as the secondary society is concerned, where they have to take steps in terms of section 29B. Because we have not gone the first step for him to come before the court and raise a contention. If he were to say that, look, I have been nominated in terms of 29 proviso to section 29, that's a different matter. 21, sorry, not section 21, if he says that I am nominated, that's a different matter. He is interloper as things stands.
Where did the society call upon this?
That is an obligation on the part of primary member society. Primary member society, I just mentioned this, it is an option of
When you are taking this decision,
yes.
having noticed that the term of the TAMPC had come to an end, did you write to them?
I will put it this way.
In fact, this question cannot be put to you. It should be put to the society.
As a matter of legal requirement, I don't answer it on behalf of the society.
Yes.
As a matter of legal requirement, a member society will opt not to participate. There is no compulsion under the scheme of the Act. The member society takes the risk of not participating. There is no compulsion for any member society to say that yes, I should. That compulsion is not there. And parallelly, there is no compulsion for the secondary society to ensure that its members are participating in the affairs. It is a democratic setup, just like how we are voting 60%, 50%. Similar things happen even in the corporate societies. It is for the member societies to be diligent about their rights and then nominate at the right time. This is the requirement of the law because the members have the option. That is the option which cannot be enforced by the secondary society because they are taking the risk under section 22, A4 and A5. If they don't participate in the consecutive meetings, if they don't utilize the facilities, then they are running the risk of losing because so this is a risk which they run. Why I am submitting this is that is a risk which is permissible to be enjoyed by the members. I cannot compel them. At the most I can compel them at the time of the election saying that no, I don't want to permit you to be voted because you did not enter utilize the facilities. You have not enjoyed the benefits of the minimum benefits which is to be accrued in terms of the bylaws. It's not like it impose upon them. To this extent, a secondary society would say at the time of elections. But otherwise, neither member society can be compared, nor the secondary society will tell the primary member to send your number. That problem is not there. It's a requirement which is never conducted in law. Only as a matter of legal need. This is second one. Now, so far as the option is concerned. Now, again, I will look at section 29.
No. Yes.
Any vacancy in the office of the members of the board of a corporate society by reason of death, resignation, removal, or otherwise. Removal can happen in any contingency. Removal can take place either under 29C or otherwise would come under 18B also. In any circumstance, wherever the vacancy takes place, then shall be filled up in such manner as may be specified in such bylaws. So it relegates to the bylaws. Then it says, provided that a cooperative election authority shall conduct the election to fill up the vacancy in the office of the director of the board if the remaining term of office of the board is more than half of its term. Now, this exercise was in fact conducted. There is no laxity on the part of the society as I gather from the arguments in past. The society did integrate the cooperative election authority. Cooperative election authority notified, but there was a COVID contingency and therefore the elections were not. Now, it was what they wanted. Wherever the elections are postponed, like this, for which the elections were conducted, this has been considered only for the remainder of the period. Reason being, object of fixing the filling of casual vacancies either by election or by nomination has been considered with reference to a legislative assembly, not immediately society. We know that this question, I leave it. The object is that if we done small, of the society or the democratically elected process can incur the expenditure. If the period is less for which the person is coming, don't incur the expenditure. Because election does incur expenditure. The question is, as on the day when the elections were required to be held, it could not be held. As things stand, when we stand at this point of time, the remaining period is barely now. As things stand now, the elections, the next elections will be barely in about 90 days. The 1 year. So for barely 1 year it has to be done. Because the burden of the poverty society goes into the public interest domain.
No, where is the question of holding election now?
Now, I just mentioned.
If his disqualification has been set aside, he is seeking to be reinstated as a director. There is no question of holding election now.
Reinstatement, I address that as an extension. I will only addressing
Yes.
the intention that whether the election should have been conducted. Election should have been conducted. Why I am making this submission is the interpretation of such provisions. Because such provisions are there in every such democratic, every such law which lays down the democratic principle for this principle, where they are permitted to court because the term is because the increase of expenditure should not be there. In respect of, let's say there will be 1 year, it is because it doesn't make any sense incurring so much of expenditure. That is how the cooperative society should also not be done. Now, when the option took place on 1816-11, it's not in dispute that the period which was remaining was less than half the term as on that day. So once the person who is required to come and serve the office is coming only for a remainder period of half the term, because the society cannot be asked to incur the expenditure for the entirety of the elections. That is ultimately the object of the act. The object of the act is either to become an elected representative if there is a substantial term. If there is a minimal term, then don't incur the expenditure. Instead, you can have the alternative. That's the object. It's a very human object because society should not be burdened with the democratic process and incurring expenditure. This is so far as conducting election is concerned. Because as on 1611, the power of nomination was there. Because now, the society exercised the power of nomination. That power of nomination having been exercised on 1611, till date, none of the other members of the society have challenged the same. It becomes very crucial and critical because we work on democratic. At the most, is one word. It is assumed that he got disqualified. There was still a body. Subsequently, a body came into existence. He came and voted against the resolution, saying that no, I don't want to stop him. Society ultimately, even if it were to be a related person, it becomes a minority. The majority of the powerful society have taken a decision that this is the best interest of the society, that we don't want to incur the expenditure. A person who is qualified because you have already read the resolution, that there were names and names, instead having some qualification, some expertise who are actually nominated for the purpose. That is the exercise which the powerful society has undertaken. Now, a person who is not even a nominated person as things stand, he cannot come and say whether the options have been made or should not have been made. This is purely an internal affairs of the secretary society of which he is not concerned. He cannot call himself an active person. Now I come to the last question you asked to whether there will be a reinstatement or not. Because for being a reinstatement, to be a director of a particular society, that is a secondary society, the requirement is at the time of filing the nomination, he should have been nominated as such by the primary society. Even after the cessation of the period under 18B, when he ceases, or under 29C is disqualified, assuming that it's set at naught, I'm grateful that Chamundi Moped's case was read. If 29C vanishes, let us assume there is no 29C. Ultimately, the substance of the argument is there is no 29C. That's the substance of the argument. If there is no 29C, he will be deemed to be a director from the date when he was elected. There is no 29C. But up to the period fixed under 18B, that's essentially what it means. He cannot say that because there is a subsequent setting of the order, 18B vanishes cannot be an argument. 18B is there. And if you're not supposed to see the regular of section 18B, it operates by operation of law itself. There is nothing required to be done by the parties. Shall cease forthwith. That means there is nothing more required to be done. His status is declared by the declaration of law. At the moment that eventuality happens, he's out. So once he's out, then there cannot be his resurrection until and unless he comes through 29E only. That's the reason why I made a mention of the first itself. Whenever any vacancy arises in any manner, whether he is there, he is not there, but the vacancy has to be filled up in terms of 29. When it comes to 29, it becomes sufficient to be this. That if society by its majority, where the member society which he claims to represent itself has not nominated him, itself has not authorized him, wants to come and say that it will not be appropriate because it's in larger interest, it's a district unit, it's a district society where I handle so many talukas. And all these talukas have concurrently said that this is the person whom we want to be a part of the board for the remainder term, and another 1 year is remaining.
I don't know what he means by saying all the talukas. It is the committee of DCC Bank which has nominated, not general board.
The committee of the DCC Bank consists of the structuring of the secondary society itself is as such that there is an adequate representation. That's why I am separating this.
That is why.
The federal structure of
Senior counsel, that is why I was asking you this question. Please point out to the provisions of law which takes care to see that if for some reason a person nominated by a primary society incurs some disqualification, is out.
that is there.
What provision is made to see that the interest of that primary society is protected? And you are saying, no, they should have come. I don't think that is the.
Certainly that can answer.
Yes.
I cannot immediately find it because Lordship is posing this question. I'm required to answer this. Lordship will accommodate another context, so I'll answer this. If there is any problem in the event of his disqualification or anything else, what should be the procedure?
Correct. What should happen to the representation of the primary society?
It's a question which I'm required to answer. But if I have this matter to do, I'll answer this.
All right.
Sorry, not that. I know that substantial getting into this, but because of this, I'm thinking it.
No, that's all right. See, when these kind of complicated issues comes up, we have been doing these routine type of cases, which is we just feel, is it a constitutional court where we are considering these type of cases? So if these type of cases come up, we are happy. We are happy to consider them. Yes, yes. Yes, yes.
It's always for the bigger child.
Para 61 and 65. 61 and 65. If the law constitutes that despite being elected, even an elected member, but we either release qualification, it could either be prior to this election or after this election. Such a person by operation of law not be permitted to continue as its character. Thus, if the right to continue as a member of the managing committee is subject to fulfillment of certain statutory requirements, it cannot be considered as an absolute right. The right to continue in office after being elected is not an absolute right down by the statutory provisions. How these circumscribed by restrictions or qualifications. Para 65. As stated, a disqualification is in essence a consequence that involves the person by wrongdoing and such person loses and benefit. However, the term of office prescribed by the statute has to do with either qualification or disqualification. If in a theoretical structure, the right to be on board of another cooperative society is dependent on the holding of an elective office in another cooperative society, and then that basic requirement there will be no illegality pertaining or seizing the right to continue in the elected office of
that was answered by the division. It said that even if the disqualification is there or not there, It's done originally, it's under section 83 will not be affected. 18 will continue to operate. Essentially, one. This question I answered.
Yes.
Great.
Release this matter on 15th of June at 2:30 p.m.
Great.
for further hearing.
Please.
Take up all the other matters next week. Wherever,
Altered matter, 86. 86.
Yes, yes. ಏನು ಹೆಗಡೆ ಅವರೇ ನೀವೇನು ಬರ್ತಾನೆ ಇಲ್ಲ ಕೋರ್ಟ್ಗೆ?
ಇಲ್ಲ ನಾ ಬರ್ತಾ ಇಲ್ಲ ನಾ ಇದ್ದೇ ಇದ್ದೇನೆ ಅವಳಿಗೆ.
ಲಾಸ್ಟ್ ಟೈಮ್ ಐ ಟೋಲ್ಡ್ ಯು ಪ್ಲೀಸ್ ಕಮ್ ನೋಡಿ ಅವರು he wants to serve some copy you are not there.
ನಮ್ ಕಲೀಗ್ ಇದ್ದಾರೆ
ಯಾರಿದ್ದಾರೆ?
ನಾರಾಯಣ ಅಂತ ಹೋಗಿದ್ದಾರೆ ನಾರಾಯಣ ನನ್ ಕಲೀಗ್ ಇದ್ದಾರೆ.
Serial number 86.
Yes.
Release this matter 21st of June 2023 at 2:30 p.m. Wherever interim orders have to be extended, you please mention it will be extended. No. Yes. Huh? ಏನಾಗ್ಬೇಕು ಇವಾಗ? ಅದಪ್ಪ ಯಾವಾಗ ಫೈಲ್ ಮಾಡಿದೀರಾ? ಬರುತ್ತೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬಂದಾಗ ನಿಮ್ಮ ಹೆಸರು ಬರುತ್ತೆ. ಎಸ್.